All rise. The United States District Court for the Middle District of Pennsylvania is now in session. The Honorable Matthew Brann.
Thank you. Please be seated. The matter before the court this afternoon is that of Donald J. Trump for President, Incorporated et al. Against Kathy Boockvar et al., docketed in this court, civil number 4:20 CV-02078. I have the list of the many counsel present, but just to confirm this for the court, if we'll start with plaintiff's counsel, if you could identify yourselves for the record, please. Mr. Giuliani, we'll start with you.
Rudolph W. Giuliani. I represent the plaintiffs in this case, but need to be admitted pro hoc vice with Your Honor's permission.
I think my staff confirms that's done.
Thank you, Your Honor.
You're a member of the Bar of New York?
I am, yes, sir.
And at least one federal court?
Yes, sir.
You're good to go.
May I take this off when I speak?
Well, that's your choice.
Oh.
I have mine off because I'm doing some speaking. And it's easiest for me to hear, and I think it's easiest for the court reporter to hear if you take your mask off when you're speaking.
It also doesn't fog up my glasses.
Well, that's the same, I have the same issue. So I understand that. All right. Is this Ms. Kearns?
Yes, Your Honor.
Identify yourself, please.
Good afternoon, Your Honor. Linda Kearns, K-E-R-N-S, for the plaintiffs. Donald J. Trump for President Incorporated. David Henry and Lawrence Roberts.
Very good. Thank you. Mr. Scaringi?
Yes, good afternoon, Your Honor. Mark Scaringi from my law firm, Scaringi Law, for the plaintiffs.
Very good. And?
Good afternoon, Your Honor. Brian C. Caffrey from Scaringi Law for the plaintiffs.
All right, very good. Anyone else here for the plaintiffs? All right, thank you. Mr. Donovan?
Good afternoon, Your Honor. Daniel Donovan for the Secretary, Kathy Boockvar.
Thank you. Mr. Breyer?
Yes, good afternoon, Your Honor. Dan Breyer on behalf of the Secretary as well.
Thank you. And you're Mr.?
Glick, Michael Glick, on behalf of Secretary Boockvar.
Are you with Kirkland and Ellis?
I am.
Thank you, sir. And then in the next row back, it's not Mr. Rogers. I think it's Mr. Rogers' partner. Is that right?
That's right, Your Honor.
And you are?
Terrence Rubin, here for Delaware County.
Right. You're with Ballard Spahr? Very good, sir. And next to you?
Afternoon, Your Honor. Michelle Hangley from Hangley, Aronchick, Siegel, Putnam, and Schiller for Allegheny, Chester, Montgomery, and Philadelphia counties.
That's right. And Mr. Aronchick, I think, is with us virtually. Is that right, Mr. Aronchick?
Yes, it is. I am here for the same clients. Thank you.
Very good, sir. Thank you. And who's behind you? Next gentleman. Yes, you, sir.
Good afternoon, Your Honor. Uzomi Plata from Person 3 on behalf of the community.
Thank you, sir. And to your left?
R.A. Holtzblatt of the firm Wilbur Hale on behalf of the DNC.
Thank you. Next gentleman? Right, and you're Cohen's, and thank you, very good, sir. And then behind you, Mr. Walzek. Thank you, sir. And to your left, well, it's Mr. Geffen, isn't it? All right. Thank No. Thank you. And to your left?
Good afternoon, Your Honor. David Ryan from Covington Borough on behalf of the
Thank you. And then I think in the back, is it Mr. Dupuis? Ms. Beecham, you're with us virtually?
That's correct, Your Honor.
Or telephonically?
Yes, Your Honor.
One way or the other, I guess. Oh, you're here. Very good, Ms. Beecham. Thank you. Is there anyone else who is here? Oh, we have some people in the back. I don't know. Who are these other individuals in the back? Presenting or just drop by?
Your Honor, my name is Bruce Mark.
All right, thank you. Yes, I'm familiar with you, Mr. Marks, at least by reputation. Anyone else? Oh, all right. Well, is there anyone else here, as when your attorney tonight is going to be presenting on behalf of either the plaintiffs or any of the defendants who would want to be identified for the record? My court reporter, Ms. Shuey, probably would appreciate receiving business cards from any of you at the conclusion of our argument today, just for the purpose of getting spellings of names, firms, et cetera, who you're with, and to the extent that a transcript would later need to be produced, you can make those arrangements with her. So before you depart the premises, she will have, of course, the docket sheet, but I think there's maybe some late arrivals who may not be immediately on the docket sheet. It would be beneficial at the conclusion of the hearing if we just pause a moment. She would appreciate that, I think. Would you not, Lori? She says she would. All right. So we're here to conduct an oral argument on the defendant's motion to dismiss. That was filed on both November 15 and November 16, 2020. Before I begin, I need some clarification, I think, as to how the defendants would like to proceed. It's the court's preference that the attorney or attorneys for one of the defendants present the general defense on behalf of all defendants, and then, if it is necessary, attorneys for the remaining defendants may raise any factual or legal issues that are specific as to that particular defendant. Do we agree, defense counsel, that would be the best way to proceed? Mr. Donovan?
Yes, good afternoon, Your Honor. I'm going to take the lead and present the arguments. Mr. Aronchek is going to do abstention, and then if any other lawyers have any other points, we've tried to coordinate that.
Right. I assumed you did, and we'll do a little round robin then at the end
great.
of that, make sure everyone's been acknowledged. Don't feel the need to speak if it's been covered. All right. So I don't think I need an opening statement, but I'll give you the opportunity to make one. I've read everything that has everything that's been docketed. There are a couple of ministerial, what I would describe as ministerial issues that I want to take up at the end. You can reasonably anticipate what those issues would be. I'm really here for the main event, and primarily. So let me just make sure before I get opening statements, if counsel wish to provide them, to clarify a few items to make sure that we're all on the same page. I think we are or can be. The plaintiff's amended complaint, which was filed this past Sunday, November 15, 2020, has essentially removed several counts from the plaintiff's original complaint. As I understand now, the only two remaining counts are for alleged violations of the Equal Protection Clause of the 14th Amendment and the Elections and Electors Clause. Am I correct? Who would like to speak for the plaintiffs on that point? Mr. Mayor?
I would, Your Honor. Yes, that's correct.
All right. Thank you. Do the plaintiffs agree that after the United States Court of Appeals for the Third Circuit's opinion at the end of last week in the matter of Bognet versus the Secretary of the Commonwealth, that the plaintiffs cannot assert standing in this circuit to raise their Elections and Electors Clause claims?
Yes, Your Honor. The only clarification is that we are going to seek leave, we've already prepared it, to amend this complaint to restore our due process claim, which we think was mistakenly removed.
Right. Well,
but we're not. But we are withdrawing. We're preserving for appeal the elector and the elections clause, but we will not be proceeding on that.
Well, that is one of the, I'm going to describe as ministerial issues that I'd like to talk about at the end of the oral argument.
Thank you.
So I'm going to circle back to you then, remind me of that, assume that was an issue, and we'll attend to that issue about a further amendment of the complaint at that point.
Thank you.
All right, so the only outstanding claim really before this court at this point is the equal protection claim. You agree?
Right now, yes.
Mr. Donovan, speaking for your collective defendants, think you'd agree?
Agree, Your Honor.
Thank
you. Yes, Your Honor.
All right. The plaintiffs bear the burden of proof, so I'll ask them to present first. Ms. Giuliani, go right ahead.
Your Honor, would you like me to remain here?
Well, is it easiest for counsel to speak at counsel table?
Sure. Either way.
That's fine with me.
That's fine, Your Honor.
If you need to use the podium, you're certainly welcome to do so. We've just found in the course of this pandemic that many times the attorneys prefer to just remain seated at counsel table. It's not my general preference, but I understand. And so if you'd like to speak, and it's easier for you to do that, stay right at counsel table.
Thank you, Your Honor. May it please the court. My name is Rudolph Giuliani, and I'm here on behalf of the plaintiffs. I thank the court very much for allowing me to be admitted pro hoc vice. Your Honor, the best description of what we're alleging, and again, on a motion to dismiss, our allegations have to be deemed to be accurate and true. Of course, that's subject to testing during the hearing. But the best description of this situation is it's a widespread nationwide voter fraud, of which this is a part. And that's probably the reason I'm here, Your Honor, because this is not an isolated case. It's a case that is repeated in at least 10 other jurisdictions. It seems to me, in the words of Emmanuel, not the prophet, Rahm Emanuel, this is one of those situations where you never let a serious crisis go to waste. It's an opportunity to do things you think you could not do before. Specifically, the crisis was the pandemic that was taking place. The opportunity to do something that had been resisted for 2 decades, which is to create a wide-scale, open, mail-in ballot process, which we had been warned about by none other than Jimmy Carter and James Baker in a report they did in 2006, I believe, on election reform. And in it, they very, very seriously warn us, quote, mail-in balloting is the largest source of voter fraud. And I don't think there's any dispute about that. Mail-in balloting is exceedingly dangerous and can much more easily be used to effectuate a voter fraud, a deliberate voter fraud. And we believe that in this case, we're going to prove that former President Carter and former Secretary Baker were prophets. This mail-in system, this new mail-in system, which, as I said, President Carter warned against, Justice Souter warned against it. Even the New York Times wrote articles explaining how dangerous this was. They've since changed their position. And this whole situation, on a smaller scale, goes back to as early as 1960, when Mayor Daley held back votes in Chicago so that he could tidy up the result to make sure it came out the way he wanted. Or you can go to 2018 in Florida, in the governor's election and the Senate election. The votes from Palm Beach County and Broward County were withheld for 10 days to see if they could catch up until a group of ballots were found heading from Jacksonville to Palm Beach that appeared to be fraudulent ballots, and the election came to an end. And Florida reformed its system, so we didn't have that happen again this year. Well, this practice of holding back votes, which happens in my city also, Your Honor, is a time-honored practice that's done in the big cities, particularly the corrupt big cities in our country. All of a sudden, we now have, it's almost like, putting them in a candy store. We now have a wonderful opportunity to hold back votes, even to produce votes after the election to make up a deficit. So what happened? In 2016, in this state, in the Commonwealth, there were only 266,000 absentee ballots. This year, so far, 2.6 million. That's a total different world. And the number of, and the allegations that we're talking about take place in each one of these counties, but the principal ones are in Philadelphia and in Allegheny. Both of them, Democrat machines, controlled by Democrats. In the case of Philadelphia, 60 years, well known for voter fraud. I don't know if you kept a list of all the voter fraud convictions in Philadelphia. I don't know if it would exceed Chicago or not. And just this year, a judge pled guilty to voter fraud, and Congressman Ozzie Myers has been indicted for it. And then I can go on and on. Relevant to this case, Philadelphia and Pittsburgh, we used in this state. Just a little bit to the west, Detroit, similar allegations. Milwaukee, similar allegations. meaning all of a sudden, for the first time ever that I've ever heard of, inspectors, watchers, observers, they're called different things in different states, weren't allowed to observe the counting of absentee ballots. I've never heard of that happening. I've never heard of an inspector being kept out of an absentee ballot counting, because that's the only time that you can assure the validity of the ballot. Because the minute they're separated, the ballot goes off anonymous and it's lost forever. You can never link it to the certifying paper. And things could be wrong with it, but you can't figure out which vote to cancel. So that's why so much emphasis is put on the inspection process before this became a major way of voting. That ability to inspect now becomes critical. It is our only way to assure that this new form of voting, which has been widely criticized as open to massive fraud, can be at all policed. And it has been not violated in this case, it's been trashed. It's been stepped all over. It's been disregarded here and in 10 other places. An eerily similar pattern. And also, in the places it happens, they just all happen to be big cities controlled by Democrats, who all of a sudden have decided that you don't have a right to inspect an absentee ballot. 50 states have this rule. I don't remember this problem ever existing before. The point is, Your Honor, this is not an accident. You'd have to be a fool to think this was an accident. You'd have to be a fool to think that somebody woke up in Philadelphia and in Pittsburgh and in Milwaukee and in Detroit and in Phoenix and all the way in Las Vegas and then way back in Atlanta. And they decided, oh, we're going to shout out all the Republicans today. We're not going to let them see a single absentee ballot. And they also did it with very similar devices, like, and I can give the court and co-counsel these pictures, like all these fences that they put up. The witnesses will describe them as corrals or cages. And they must have had a subcontract with a major company to get all of them in all these places. So the point that I'm making, Your Honor, is this is not an isolated case, peculiar just to Pittsburgh, Philadelphia, or the Commonwealth of Pennsylvania. This happened in at least 10 other jurisdictions at precisely the same time. Let me get to the individual plaintiffs, because in many ways, what happened to them is totally outrageous. Mr. Henry, who is in Lancaster County, voted by absentee ballot. I believe he made a mistake in his vote for absentee ballot, a critical mistake, usually, under your law, which is he failed to insert the ballot in the secrecy envelope. So the ballot looks something like this. I used to vote by absentee ballot a lot because I traveled a lot. And you're supposed to put it in an inner envelope. Outer envelope has all the information we need to see. And I've been in these contests myself in New York. They're kind of like wrestling matches. And instead of doing it this way, he unfortunately just put the ballot in without the, they call it the secure envelope, so that his vote can remain anonymous. So it came in. When they opened it, they quite properly disregarded the ballot, because your law is quite strict about that, as it should be, because again, this is the only way to secure the validity of these votes. His vote was discarded. Very similarly, the same thing happened to Mr. Roberts. However, in Philadelphia, in Pittsburgh, Allegheny County, in the other counties, with the encouragement of the Secretary of State, they were told to disregard that. And they were allowed to cure. They informed people that there was something wrong with their entry. And again, they're quite strict. If you leave out in New York, we call it an assembly district. I'm not certain how you do it here, but you've got to have your assembly district. You've got to have your precinct number. You have to have your voter ID number, address, and you need to sign it. Any one of those things are missing, ballot's tossed. Anyone. Now, in the case of Mr. Henry and Mr. Roberts, they had made mistakes. They were given no opportunity to cure. Thousands of people. And since we haven't had discovery yet, we don't know how many, could be hundreds of thousands of people. In a certain part of the state, let's call it the more Democrat part of the state, were given a very, very fulsome opportunity to cure. And we have many cases of their being told, oh, you made a mistake, redo it. You made a mistake, you didn't sign your full name. You made a mistake, you didn't put the address in. Your Honor, that's a classic violation of equal protection. I have no idea what their standing objection is. That is exactly Bush v. Gore. Exactly. If you were teaching a law school class and you wanted to give an example of a Bush v. Gore violation, you can use this as an example. They are being discriminated based on their location. In one part of the state, you can cure the ballot. In the other part of the state, you can't cure the ballot, which means they would deny their right to vote. I don't know what's more serious than being denied your right to vote in a democracy. And therefore, how they can object to standing is almost frivolous, Your Honor. Now, let's get to the campaign. Unlike Bogner, which is the case that, has caused the repleting of the pleadings, we're totally different than Bogner. Bogner was a harm that might possibly happen in the future. It was inchoate. It hadn't happened. This is a harm that has happened. Mr. Henry and Mr. Roberts have been denied their right to vote. Their votes have been canceled. The Trump campaign has been treated totally differently than the Bush campaign. It depends on where you are in the state. The rest of the state complied with the law and allowed observers. We have no complaints from the Republican or neutral part of the state about this happening. The only place we have it happening en masse is in the Democrat, heavily controlled counties that you can call counties controlled by a Democratic machine that have quite an impressive list of voter fraud convictions as part of their history and tradition. And all of a sudden, with this greater opportunity to do it, they did it on a grand scale. So I don't understand what the standing argument is. I don't understand how the President of the United States, the campaign, doesn't have standing to assert, if we're right, which we have to assume here, that we were treated totally differently in one part of the state, namely Philadelphia and Pittsburgh, where our inspectors didn't get to see a single ballot. And in the most of, if not all of the rest of the state, we had no problem with that. Just like we've never had a problem with that in 50 years. This has never been a problem before. That's an equal protection claim. Now, I believe we're going to prove it. I believe we're going to prove it way beyond even the numbers we have now. One of the problems that we have in this case and why we had to amend is because, as compared to last week, we have twice as much evidence this week. And it's not just here, all over the country. Just yesterday, in Clark County, which is Las Vegas, the election board in Clark County, which is 5 Democrats and no Republicans, reversed an election of a Democrat based on irregularities in Clark County. Those are exactly the same irregularities that we are asserting in Clark County, except he was only part of it, and we have 5 times more. So we're not bringing up a frivolous argument here, Your Honor. This is happening in all these places. We have already begun 4 lawsuits. We've got another one for tomorrow. We've got 3 others asserting just about precisely the same thing. And how this is not an injury, real, tangible, actual, already happened. And why do we come to a federal court? We come to a federal court because the federal court enforces and protects people against violations of equal protection. It protects voters who have had their vote stolen from them. It protects a candidate who, it appears, if we prove our allegations, had an election stolen in the state of Pennsylvania. And I believe in other states. Where else should we come but to a federal court when we're talking about an election for President of the United States. This is not an inchoate injury. This isn't an injury that might happen, a hypothetical injury. It happened. The votes have been counted. The illegal ballots that were not inspected at all have been entered and counted. In fact, precisely 682,770 that we can count now. Last week, it was about 340,000. And probably when we get to the hearing, it'll be over 700,000. And that's only in Allegheny County and in Pittsburgh and in Philadelphia. The whole state, we're at about 1.2 million. What am I talking about? I'm talking about absentee or mail-in ballots that were entered without a single Republican having the opportunity to observe anything about the ballot. They were kept behind barricades so far away that even as to the closest you couldn't see it, you have no possible chance of seeing it in the back. This is absurd. I mean, this is a disgrace. This is like saying to the General Assembly of Pennsylvania, we don't care about your law. We run Philadelphia the way we want to run Philadelphia. You say we can't cure ballots? We can cure ballots. You say you have to have people present? Yeah, we'll have them present, except we'll have them behind barricades so far away they can't see a darn thing, even when they tried to do it by binocular. Isn't this ridiculous, Your Honor? This is supposed to be an inspection of something darn important. This woman's got to use a binocular? And this isn't fraud? A binocular. This is totally laughable. This couldn't happen in a neutral county that wasn't controlled by one political party, and in that particular place that has a long history of corruption. If we have to enter those in the record, we're more than happy to show all the political corruption convictions in Philadelphia over the last 20 to 30 years. May they fill an encyclopedia. This doesn't happen in an honest place. It didn't happen in the rest of the state, which is an honest place. It didn't happen in the rest of the place, even that's democratic, but not machine democratic. This is an outrage, Your Honor, to do this to people. I have several people back here who endured it. In Philadelphia, it got nasty. In Philadelphia, we objected. We were told we'd be arrested. We were pushed further back. Several people were assaulted. Several people were pushed around, including women. And then we went to court, and we got a clarification from the court that we could be 6 feet closer. And when we came back, and we have 2 witnesses to prove this, when we came back, the gentleman who got the order forgot to bring the order with him. He told the sheriff, we now want to move 6 feet closer. We moved 6 feet closer, and they moved them 12 feet further back. Net result, 2.5 days in Philadelphia, we didn't see a single ballot. Same thing, 2 days in Pittsburgh, we didn't see a single ballot. None, 0. These people wasted 2 days of their time to be made fools of, pushed around, threatened, and when we got the order and we showed it to the sheriff said, if you move 1 step closer, I will arrest you. This is America. They're going to arrest somebody because he wants to observe a ballot to make sure that his candidate isn't being cheated in a place that is well known for cheating. I mean, he wasn't exactly in heaven. So the net result is at the point that we are at now, 338,000 in Pittsburgh, something over 340,000 in Philadelphia, for a total of 682,770. And let me correct what I said. When you look at the 7 counties, you put them all together, it's 1.5 million. 1.5 million votes that were entered illegally. 1.5 million votes that went in there, and the only person that knows if it complied with the law is a employee of a Democratic-controlled city or county. Nobody else. In many cases, even Democrats weren't allowed to see it. Democrats weren't allowed to see it because they couldn't count on the fact that all Democrats are crooked. They're not. decent Democrat seeing this would have said, what the heck are we doing? In fact, one in Detroit did do it and is a witness for us. She was so disgusted by the process, she came and reported it. So they made sure it stayed with their little mafia, who would be nice and quiet about it. They didn't let a Democrat see it, didn't let a Republican see it. Nobody got to see it. Completely flaunting the law of Pennsylvania, but even more importantly, completely, and that's why we want the due process count back, completely violating what has been universally recognized as a thing of fundamental fairness with these ballots. Every state in the union has an inspection requirement. That's not by accident. And if it didn't have an inspection requirement, now that a third of our vote is being counted by absentee ballot, well, you got to have one, but you don't just have to have one, you have to have one that you're going to enforce. If this is allowed without serious sanction, meaning the canceling of these ballots, this will become an epidemic. I mean, you give them an inch, they're going to take a mile. They've already taken a mile. They take a mile, they're going to take a whole city. This cannot be allowed. And what did they steal, really? Well, they stole an election, at least in this Commonwealth. These votes are way more than enough to overturn the results of the election. And one of the questions in Wagner was, did they have enough votes to overturn the results of the election? We have 10 times more votes than we need, and we're still getting complaints. It would overturn the results of the election. So this is a real controversy. This is a case, and it's a controversy. And I don't know, since I went to law school, that's always been the simple test for whether you have standing. And I really do believe their argument on standing is just an argument to delay this, because they like to delay this as long as possible. It's certainly a frivolous argument, Your Honor. Your Honor, I ask the court to allow us, first of all, to deny the motion to dismiss so we can quickly move to starting to put before you the proof that we have. We have hundreds of affidavits, Your Honor. The question here is going to be, if we proceed to a hearing, if that's your decision, the question is going to be, how do we present that evidence without burdening the court? I mean, a lot of it is repetitious, but repetition proves it over and over again. I'd say we have 300 either affidavits, declarations, or our own statements that we've written down that will be subjected to the process of affidavits. And we do have, in addition to these pictures, which I'll submit to the court, should I mark them as an exhibit, Your Honor, or?
You're welcome to do so. Mr. Donovan and defense counsel, you had an opportunity to see.
Sure. No, they haven't. I'm going to give it to them now, Your Honor.
Or have copies of them available?
I haven't, Judge, and I don't believe they're part of the complaint. I have no objection to looking at them, but I'll get to that when I see them.
No, they aren't, Your Honor. They're in paragraphs 132 to 149, we allege this.
Well,
okay. So can I mark this?
Let's go back to that, but if you can supply a set to Mr. Donovan, and what are the paragraphs of the complaint? 132 to what did you say?
I believe it's 132 to 150.
Thank you.
So,
let's continue your argument. We'll get to.
Well, I'm just at about the end, Your Honor. So, I'll mark just so that we're clear at what they are. The first one is a picture of the center in Philadelphia, where the woman appears to be 20 to 30 feet away from the closest counting area, quite obviously unable to see anything of significance. So I'll call that Exhibit A and give it to co-counsel. And I used to be a clerk, Your Honor. Hope I'm doing it right. I'll make it Exhibit A.
Yeah, so far so good.
Well, in case I need a job after this. This is Exhibit A. Again, a second picture to show how far away they were. I mean, and as you might imagine, there was very serious objection by these people to this. The whole day was wasted, standing there like potted plants. The The first two, A and B, are Philadelphia. Here you are, sir. Thank you. And the second two, which we'll call C, is a young woman having to use a binocular to try to see. As you might imagine, it didn't accomplish anything. She wasn't able to see anything. Largely because the ballots are here, you can't find them. There's C, that's Pittsburgh.
Sir, Judge, may I have a representation from counsel that A and B, as a kind of officer of the court, is Philadelphia?
I was told that.
Well,
That's my understanding, sir.
okay.
If it isn't, I'll correct it.
So Mr. Giuliani's representing that what are proposed to be, what have been marked and are proposed as plaintiff's exhibits A and B are from Philadelphia County. I think exhibit C, he's indicated is from
Allegheny County. And the last one, exhibit D, is also from Allegheny County. And since I just got these coming here today, I will check, and if they're different counties, I'll correct it, Your Honor. So again, in conclusion, Your Honor, we would ask you to deny the motion to dismiss so that we can, as quickly as practical, move to the part of it where we can present the evidence so that we can show you that what we are alleging, which you have to deem to be true now, is in fact true, and that we can establish it and prove it with witnesses, photographs, videos, audios, and expert witnesses.
Very good, sir.
Thank you, Your Honor.
Thank you. Ms. Kearns, Mr. Scaringi, you have anything to add by way of at least initial argument before I turn to the defense?
No, Your Honor. As you know, I filed a motion to withdraw with the agreement of my client, and I defer to the new counsel's strategy.
Thank you. I know that, Ms. Kearns. I didn't act on that. I let Texas counsel withdraw last evening. I wanted you here because I had some specific questions that I'll circle back to later. But I thought you, since you've been involved in representing the Trump campaign from the beginning, might best be able to answer. You are welcome if you are not able to answer those questions, or if you would prefer to defer those questions to Mr. Giuliani and Mr. Scaringi, you're welcome to do so. But I wanted to have you here today because I had some questions specifically that I thought specifically you could answer.
Absolutely, Your Honor. I'd be happy to answer anything that you ask.
Very good. Thank you. Mr. Scaringi, anything to add to Mr. Giuliani's argument?
No, Your Honor.
Thank you.
Your Honor, may I just also point out that Linda is going to be representing the campaign and Donald Trump in the state court actions.
Understood. Thank you.
Continue to be part of the team, but not just on this particular.
Understood.
I have continuing cases in both the Supreme Court and the Commonwealth Court that I'm handling.
Very good, Ms. Kearns. Thank you very much. All right, Mr. Donovan, I'll turn to you next.
Thank you, Your Honor. May I use the podium?
If you prefer, that's fine.
I do. Thank you.
Certainly. Leave that for you, Lori. Are you going to show these on the screen as well, or are they just?
They're just hard copies.
Yeah,
I have
fine.
some extras for people.
Yeah, that's fine.
I gave some to you.
Mr. Giuliani, you have a copy of.
I do, Your Honor.
Your Honor, Daniel Donovan for the Secretary. Let me start on behalf of the Secretary to thank you for all the efforts and your staff. I know you went through to have us here live. I think that's important. But I also know it's a difficult task. So on behalf of the Secretary, thank you. The November 23rd deadline for county boards to certify the election results are fast approaching, and the Secretary and her team are working to certify the election results of the over 6.8 million votes cast here in the Commonwealth of Pennsylvania. I know you've received a tremendous amount of briefing. I intend to do my best to distill the arguments rather than repeat them. A couple observations. Let me start, Judge. I am going to focus on the first amended complaint filed by the plaintiffs. Much of, I think, counsel on the other side of the aisle focused on allegations that are not in the complaint. In fact, the canvas watcher allegations were deleted out of the amended complaint. And the plaintiffs were kind enough to provide a red line version, so those claims are out, but I'm going to focus, Judge, this afternoon on the motion to dismiss standard. Okay. So let me start and address what this case involves and what this case does not involve. And just for ease, for those that have a hard copy, I'm on page 3 of the slides. So at this point, we have a single count, a federal constitutional equal protection claim. And the plaintiff's factual predicate in the first amended complaint can be distilled into a challenge to 3 election code practices, Judge. First, plaintiffs allege that certain voters were permitted to cure deficiencies to their mail-in ballots before Election Day. That's 1. 2, plaintiffs allege that certain voters were apprised that their mail-in ballots were defective, and some of those voters elected to vote a provisional ballot on Election Day. And of course, I know Your Honor knows, but so others know, provisional ballots go through a process. They're reviewed pursuant to the Pennsylvania Election Code that involves a public process before county boards, and then they can be challenged in state court if there's any challenges to this. So that's 2. And then number 3, Your Honor, is plaintiffs allege generally that certain mail-in ballot envelopes were not filled out consistent with the Pennsylvania Election Code, and unspecified counties should not have counted those, although they allege generally some might have. Those are each the 3 practices that are alleged to be violations of the Pennsylvania Election Code, and that is, under state law, plaintiffs argue certain ballots should not have been counted. That is the basis in the complaint for the equal protection claim. I believe it's just as critical to summarize what's not in the complaint. There is no claim in the complaint that any qualified Pennsylvania voter cast more than 1 ballot that was counted. There's no claim that any qualified voter who submitted a mail-in ballot had his vote wrongly rejected. There's no claim that anyone not eligible to vote in fact voted. And there's no claim of voter fraud that affects the equal protection claim. That's not in the first amended complaint. So to be sure, all qualified Pennsylvania voters have an equal right to vote. Every voter in every county, including voter plaintiffs here, had the right to vote either in person or by mail. And there's nothing unequal about the ability to cast a vote in this case. And I'm going to get to some of the cases, actually, that talk. I know one of yours does as well, Your Honor. But at the end of the day, this case is about a claim that a very limited number of qualified voters had their votes counted. In fact, counted when plaintiffs argue under state law, they should not have been counted. As relief, the plaintiffs ask, Your Honor, to enjoin certification of every ballot in the state of qualified electors, and they do that by alleging that some state officials did not follow the code. That's the allegation. That's not an equal protection claim. I'm going to walk through that, Your Honor. No federal court has ever recognized that theory. And anything other, I submit, than counting ballots lawfully cast by qualified Pennsylvania electors is not only against the law, I submit it's un-American, but it certainly is not a federal constitutional claim. So now, Judge, let me turn, actually, if you just go back to slide 2, I had them a little backwards there. These are the 4 issues we're going to address this afternoon. First, Judge, is the lack of standing by any of the plaintiffs to pursue their equal protection clause. This jurisdictional defect, most recently made clear in Bognet, as well as Your Honor's case I'll get to, remains fatal to the plaintiff's claims even as amended. That's 1. 2, plaintiff's claims fail to state an equal protection claim pursuant to 12b-6. Plaintiffs attempt to create a federal constitutional equal protection claim when what they are challenging are state law practices. And we're going to show that that doesn't establish, even at the motion to dismiss stage, an equal protection clause. Third, Mr. Aronchek, once I pass the virtual podium to Mr. Aronchek, he's going to address abstention and the final arguments, and I understand some other counsel may have some other points for Your Honor. So let me start with standing, Judge, and for that, I'm going to turn to slide 5. Judge, plaintiffs lack standing to assert the equal protection claim. And I would submit to the court there's three cases I'm going to focus on. First is Your Honor's case, the Pennsylvania Voters Alliance from October, Your Honor's decision on standing there. Second, the Bognet decision that followed yours. And then third, Judge Ronjon's decision in the Western District of Pennsylvania with the same plaintiffs who made equal protection theories there. That's what I'm going to focus on, Judge. And because I went through your opinion, and as Your Honor says about standing, Article 3 of the United States Constitution limits the power of the federal judiciary to cases and controversies. As I've heard it said, federal courts have immense power, but limited jurisdiction. And this is what you go on to say when you say it's an irreducible constitutional minimum to address that. Your Honor then goes through the law on standing for particularity, speculation, causation, and redressability. So I don't intend to repeat the law, Judge. I know it's in your opinion, but I want to apply these facts to it. So the plaintiffs in the First Amended Complaint, Judge, on standing are actually quite limited. They argue some qualified voters were able to cure their deficient mail-in ballots or vote provisionally when they found out their mail-in ballot was deficient. The only specific allegations they refer to are to Philadelphia County in the First Amended Complaint. There's nothing as to 6 other defendant counties, and there's nothing as to the other 60 counties in the Commonwealth. And these allegations, I'm going to show under settled case law, do not establish standing for the individual voters or the campaign. In the end, Your Honor's case, Voters Alliance, Bognet, and the Trump campaign versus Boockvar in the Western District all lead and support dismissal based on standing. So I want to turn to Bognet, Judge. Bognet faithfully applies these principles, as you know, Chief Judge Smith wrote for the Third Circuit. And he explained, this was a quote at star 6 of the Westlaw. If the injury you claim is an injury that does no specific harm to you, or if it depends on a harm that may never happen, then you lack an injury for which you may seek relief from a federal court. And I'm going to show you the plaintiffs fail to assert particularized concrete injuries under the law. And why is that? Well, the premise of the plaintiff's challenge is that certain allegedly invalid votes may dilute, I think that's what Mr. Giuliano was talking about, may dilute other votes that they believe were validly cast in the state, Commonwealth. But that's not a concrete and particularized injury under Voters Alliance, Bognet, or even the Trump case from the Western District. The injury is not particularized to the voters or to the campaign. And I submit Bognet squarely forecloses plaintiffs' attempt to manufacture that claim. And I'm going to show you some of the pieces of that now, Judge. In Bognet, as you know, the Third Circuit held that the plaintiffs lacked standing to bring Equal Protection Clause claims alleging vote dilution because such harm was neither concrete nor particularized. Specifically, the court held counting ballots in violation of state law is not a concrete harm under the Equal Protection Clause. They could challenge in state court, as Ms. Kearns is doing, but it's not an Equal Protection Clause under the United States Constitution. And the court further held in Bognet that the alleged counting of improper votes is a generalized grievance that is insufficient to confer standing. And here, Judge, I know you've looked, but if you look again at the First Amended Complaint, it boils down to allegations that the election code was not followed in certain instances. Well, Judge, if you turn to slide 6, if you would, I put a piece of Bognet up here. In the Third Circuit, writing, a vote cast by fraud or mailed in by the wrong person through mistake or otherwise counted illegally has a mathematical impact on the final tally and thus on the proportional effect of every vote. But no single voter is specifically disadvantaged. Such an alleged dilution is suffered equally by all voters and is not particularized for standing purposes. And Judge, the sole equal protection claim in the First Amendment complaint boils down to a claim that some, but not all of the defendant counties counted mail-in ballots with some facial defect in them, or they should not have been counted. Nothing more is left in the complaint, Judge. And Bognet, I submit, holds plainly that plaintiffs do not have standing to assert those votes, or excuse me, to challenge those votes that arguing they were diluted under federal law. Whether the equal protection claim is predicated on unlawful counting, as they allege, or counting ballots that were corrected Chief Judge Smith's analysis in Bognet confirms that plaintiffs lack standing. And in both instances, the allegations amount to a generalized grievance that the Pennsylvania election code was not followed. Every citizen has an interest in the proper application of the election code, and plaintiffs have no concrete particularized and nonspecific. And the source of these allegations, it's a matter of state law, Judge, which makes any alleged harm abstract for purposes of equal protection. The plaintiff's only basis for allegedly dilution from the unlawful counties is the election code. That's not a concrete harm. Now here, plaintiffs allege that some electors were treated unequally, but that's not a particularized harm to them. It's a generalized claim, again, Judge, that the Pennsylvania election code was not followed in certain instances. And here, Judge, I go to slide 7. This was again addressed in Bognet. On the issue of standing, Third Circuit held, precedential decision, the logical conclusion of the voter plaintiff's theory is that whenever an election board counts any ballot that deviates in some way from the requirement of a state's legislatively enacted election code, there is a particularized injury, in fact, sufficient to confer Article III standing on every other voter, provided the remainder of the standing analysis is satisfied. But allowing standing for such an injury strikes us as indistinguishable from the proposition that a plaintiff has Article III standing to assert a general interest in seeing the proper application of the Constitution and laws, a proposition that the Supreme Court has firmly rejected. And that's what we have here, Judge. The campaign's argument is no different. The campaign argues that the counting of alleged cured ballots or provisional ballots, but it would not affect the campaign in a particularized way. And why is that? Because the ballots that are being counted are for all races on the ballot, federal and state. I know sometimes we only focus on certain races, but the ballots, as Your Honor knows, for all federal and state elections. And for whoever that voted for, all candidates in state and federal races were subject to the same rules. And Judge, it's not just in this circuit. I would direct the court's attention to slide 8. This was in Hotz v. Hollins. Again, this was a voting case, recent November 2nd, 2020 from the Southern District of Texas. Here they said the plaintiff's general claim that Harris County's election is being administered differently than Texas's other counties does not rise to the level of the sort of particularized injury that the Supreme Court has required for constitutional standing in election cases. And Judge, that was a case relating to Harris County had that drive-through for COVID, you could drop off your ballot, but no standing there. So in the briefing, Judge, there was some allegations that plaintiffs, that they were denied the vote, okay? But plaintiffs don't actually allege vote denial. And let me start with the two voters. If the concern of the voters was that their vote was denied, they would have sued their own counties, Fayette and Lancaster County. They're not defendants here. The defendant counties in this case did not in any way deny those two plaintiffs their vote, nor could they. They're not voters in those counties. Their home counties did not count their vote. And according to the plaintiff's allegations, they admit they did it wrong, and they should have. And the request of relief in this case is to stop votes of people in other counties. And under standing case law, they don't have standing to assert that. It's generalized. And that goes to slide 9, Judge. We now go to, well, can the candidate sue for that? In federal court, under the U.S. Constitution, not Pennsylvania law. In slide 9, Bognet says for a candidate to have standing to enjoin the counting of ballots arriving after Election Day, such vote would have to be sufficient in number to change the outcome of the election. And we heard numbers today and pictures, Judge. I don't have everything. I'm just a lawyer, Judge. But I looked at the complaint, and none of those numbers are in there, Judge. And that's what I show on slide 10. What is not alleged in the complaint does not allege which counties publicized the cure process, whether voters cured their original ballot or cast a provisional, whether any such county has cured any provisional ballots, and whether such counted ballots were cast for President Trump or anyone else. And Judge, this goes to plaintiffs allege injuries that are speculative. These speculative injuries cannot give them standing in federal court. The campaign does not allege the issues they raise in the amended complaint would change the outcome of the election. I heard from counsel this morning, but that's not in the complaint, Judge. There are no such allegations. Now, they do argue they'd like discovery to find facts, but, Your Honor, I've been before you before, and I know that under the rules and the understandings, plaintiffs must make allegations that survive dismissal before discovery. And finally, there's no sufficient allegations of an imminent injury that they allege. They advance specific allegations regarding Philadelphia County in the complaint. That's at paragraphs 127 and 128 related to their equal protection claim. And there they allege that Philadelphia County allowed certain voters to cure ballot envelope defects by casting provisional ballots. But plaintiffs don't allege whether those voters actually cast such a ballot or that Philadelphia counted those ballots. And this is what I think, Judge, is the death knell in the motion to dismiss it. There's no allegations about any other county then. And there's nothing related to the other 60 counties in the common law. It's just speculation. So let me wrap up standing, Judge. I come back to the trinity of cases. Your Honor's Pennsylvania Voters Alliance from October, Bognet from recent, and then the October decision by Judge Ron John in the campaign versus Boockvar. All three found lack of standing, all laid out the law, and all foreclosed standing in federal court to address these issues. And why is that? The two voters, Mr. Roberts, Mr. Henry, they allege vote dilution. They're not challenging their own counties. And a general grievance that counties should follow Pennsylvania election code and not count other votes is not permissible in federal court. And Your Honor, I just covered for the campaign, there's no vote denial. The campaign's not a voter. But they don't have standing. There's no vote dilution standing because the allegations they assert under Bognet and the progeny don't provide for standing for these allegations. That's not an unequal or competitive disadvantage under Bognet whether valid Pennsylvania electors were able to get their ballots to be counted. So, Judge, I'm going to stop on standing, although I'm happy to answer any questions as I go, Judge, but I'm now going to turn to the equal protection claim. That's slide 11, and I'll go over to slide 12. But let me start on the equal protection claim. So on standing, Judge, I just want to say, I think that's the place to stop, Judge. I think that's what it is. There's challenges in state court, and no one's trying to stop any state court, valid state court. But here in federal court, we have limitations, and I don't believe they've satisfied it, Judge. That's step one.
But I don't want to interrupt your flow of argument. But
please.
With regard to and Mr. Giuliani and Ms. Kearns can answer this question as well, but just to orient me, how many matters are pending in Pennsylvania state courts, and if you know, which common pleas courts are impacted?
Yeah, so the one I'd start with is in the Pennsylvania Supreme Court currently is the issue that Mr. Giuliani and Ms. Kearns referred to about whether a canvas under state law is at 6 feet, is it 12 feet, that issue.
And that's an appeal to the Supreme Court of Pennsylvania?
Yes, it's currently there. There also have been, and I know Mr. Aronchek was part of these, so he could probably hit these better, some in the state courts have already been adjudicated. And that's where Mr. Aronchek's going to make the point. There's abstention issues. There's Rooker-Feldman issues. They've been litigated. And there's some ongoing that Mr. Aronchek can, because he's involved in it.
Can he better answer that question?
Yes, he can on the common pleas.
That's fine. Let me defer those questions to him. I assume he'll answer them as part of his argument. All right, go right ahead, sir.
Okay. But that I And it must be dismissed, Judge, if you get to it, because it fails to state a cognizable claim. And again, I just want to emphasize this because it is the current complaint. The plaintiff's claim is that certain counties permitted voters to cure defective mail-in ballots and have those votes counted, and that certain ballot envelopes were not fully filled out but were counted. This alleged violation of state law, simply under the cases I'm going to go through, cannot establish a federal equal protection clause. The amended complaint continues to try to create a constitutional claim out of what's called, I think in both Your Honor's case and other cases, garden variety election practice disputes. And now, Judge, I'm going to refer to Judge Ron John's. There's two cases. There's what is the campaign versus Secretary Boockvar from earlier this year in the Western District. And in that, Judge Ranjan held that garden variety election irregularities are simply not a matter of federal constitutional concern. And Judge, this is slide 12 for those. It's not a matter of federal constitutional concern, even if they control the outcome of the vote or the election. And that's at star 49 of the Westlaw site there, Judge. And the plaintiff's allegations about notice and cure do not state a constitutional claim either. The claim does not involve any persons who are not qualified Pennsylvania voters in the Commonwealth. Instead, plaintiffs allege that certain qualified voters were given notice, or they figured out that they're mail ballots, because you can go online on the SURE system, and it says whether your vote is canceled, and they might have come in and voted provisionally. And again, I want to stop here. Both under federal law and Pennsylvania election code, if a voter shows up at a polling place and says, I want to vote, even if the poll book shows that they've already voted, they have to be provided a provisional. And what that means is that then gets figured out later. That goes through the provisional process. So that's the allegation here. Well, so what's alleged? Well, instead, plaintiffs allege in the amended complaint, they don't even allege that any county even counted any such cured ballots. The provisionals, remember, they're going through the process. The amended complaint, again, I come back to, they only allege that there was a cure process with respect to Philadelphia County at paragraphs 127 and 28. And the plaintiffs offer nothing as to the other 6 defendant counties and offer nothing as to the other 60 Pennsylvania counties. So let's turn now then, Judge, to what do they allege? Well, the plaintiffs do not and cannot allege that any notice and cure process changed the ability of an actual voter, because that comes back to there's no challenge that anybody who voted wasn't a qualified Pennsylvania elector. Voters in the Commonwealth could vote by mail or in person. That was equal throughout the Commonwealth. That was a choice. And let me pause there, Judge, because I think at this point, that choice for mail-in ballot was passed bipartisan in the Commonwealth. It was passed by the Republican legislator and signed by Governor Wolf. Okay, so to the extent there was some suggestion that any party, and in fact it was passed, and Secretary Boockvar and her team worked hard to make sure everybody in the state was able to vote however they chose during the pandemic. And any suggestion otherwise is just not true. But also, we go to the claim that, wait, some voters got to vote a provisional. But again, Judge, that's expressly permitted and required under the Pennsylvania Election Code. All the U.S. Constitution requires, and I'm going to get to the cases, is that a person have the right to vote and that the plaintiff voters do not dispute here that they had the opportunity to vote. I agree with Mr. Giuliani. Both of them said, we mailed in our votes, we did it wrong. They were what we call naked ballots. But there's no dispute. They admit that. They had the opportunity to do that. Now, because plaintiffs cannot demonstrate any burden on the right to vote, they had the opportunity. They say, well, allowing other citizens to cure defective ballots before the close of the polls. For your honor, it's rational basis. And there I would refer to the Husted case out of the Sixth Circuit, 697 F3rd at 429. And that's then rational basis. And there's plenty of reasons to have such processes. Some counties might have known they were going to have higher rates of mail-in ballots. And the counties can allocate resources, Judge, differently without creating a constitutional issue, and I'm going to go through those cases. And just a couple other related examples, Judge. Different counties have different number of polling places. That's been determined. That's not an equal protection claim. Judge Ranjan, in the campaign's case, said, well, wait, having more drop box locations in some areas, that has higher fraud, they alleged. And Judge Ranjan said, it's not an equal protection violation. It's just not. And the plaintiffs also cannot argue that the counties were somehow limited from having cure processes only in certain counties. The secretary, Judge, I know it's attached, the secretary issued her guidance on to all counties, and encouraged all counties to make information available to both the parties and to put it in the SURE system. The fact that some counties may have emphasized these more than others is simply not a constitutional violation. And Judge, plaintiffs don't grapple with these cases.
Why isn't it?
I'm sorry?
Why isn't it, if indeed?
Yeah, and I'm going to start with going through those cases, Judge, and...
That's all right. Then weave it in.
Yeah, okay, thank you. You were a little ahead of me. That's where I'm heading now, though. And Judge Ranjan, let me start, found that the counties may, consistent with equal protection, employ entirely different election procedures and voting systems within a state. And that's slide, maybe one forward. Yep. On the next slide, Judge, it shows that if this were a true equal protection problem on slide 13, then it would transform every violation of state election law, and actually every violation, into a potential federal equal protection claim requiring scrutiny of the government's interest in failing to do more to stop. That is not the law. And then when we look at slide 14, Judge, again from Judge Ranjan, again, there they were challenging different drop boxes in different counties. On slide 14, he held that the counties may, consistent with equal protection, employ different election procedures and voting systems within a single state. And that's what I want to turn to for a moment is the Trump campaign's case against the Secretary in the Western District. With the decision from Judge Ranjan, they're here. They didn't appeal that decision. And the time has passed. And I want to explain why this claim now is not a constitutional violation, because these nearly identical equal protection theories were asserted by the campaign in that case. There, just like here, the campaign alleged that Pennsylvania's uneven use of drop boxes in different counties violated equal protection for voters in counties without drop boxes. They said one county and the other. And Judge Ranjan, and this is at star 38 of the Westlaw decision, and he kind of goes through it, Judge. Here, he held that equal protection does not mean that all forms of differential treatment are forbidden. And actually, Judge Ranjan held the campaign's equal protection claim, quote, fails at the threshold because the plaintiffs have not alleged that Pennsylvania's system of different use of drop boxes, or here different cure processes, will result in the dilution of votes in certain counties and not others. This goes to the point, it's a statewide. After analysis, Judge Ranjan held his rejection of the equal protection claim is consistent with many courts that have recognized that counties may, consistent with equal protection, employ different election procedures and voting systems within a single state. And that's at star 44 of that opinion. And Judge, before I proceed, I want to address, Mr. Giuliani addressed Bush v. Gore. And a couple points. First of all, the bulk of the claims here go to notice and cure process, which goes to differences the way counties gave notice, not the way votes are counted. But the flaw in the plaintiff's argument, Judge, is the Supreme Court in Bush v. Gore found Florida's interest in certifying its election results to be paramount. And because they said we got to make sure the Secretary certifies that, they halted the recount there because that was having issues that would prevent Florida from certifying the results. Here, Judge, the plaintiffs are asking you to do the opposite. They're asking you to get in conflict with Bush v. Gore. They're asking you to enjoin certification. And they want the court to issue an injunction that prohibits certification. And again, Judge, this isn't the first time this came up. Again, Judge Ranjan's decision at star 42 to 43 addressed the campaign's argument in that case related to Bush v. Gore. And he held that the claim that different use of drop boxes could be an equal protection clause under Bush v. Gore, he said, is wrong. Such dilution, that is, if it actually happens, such dilution impacts the entire electorate equally, not just voters in counties where it occurs, end quote, star 42. And I think that answers the question, judges, for federal court claims, equal protection, even taking what they allege is true, that voter dilution impacts the entire electorate equally, not just voters in the county where it occurs. And Judge Ranjan then held that the alleged harm by the campaign is, quote, categorically different from the harm at issue in Bush and cases like that.
Mr. Donovan, hold on just a moment. I'm told we have some technical issue. Mrs. Reinhart, what's going on? Say again. How long will it take? So all the telephone lines are off? What about the virtual? What about the attorneys virtual if they're still on? That's fine. All right. So, I'm sorry to interrupt your presentation. What I'm advised by my staff is that we had, I think ultimately there were 8,000 telephone lines set up through AT&T so that any journalist, any citizen, etc., who expressed an interest in listening to this oral argument today could tune in. Well, guess what? The lines have dropped. So, naturally. So, So we're going to take a short recess, and it'll be short, for the IT department to get this promptly corrected. We've done this before, but we haven't had this many lines, haven't had quite this much interest. I'm not suggesting, by the way, there are 8,000 people on the line. The clerk of court told me before I came out into the courtroom there were at least 3,700 people who had dialed in, which is wonderful as far as I'm concerned. But they can't hear. So, counsel who are here virtually, you can hear me? Mr. Aronchek and who's Ms. Meacham, you can hear me?
Yes, Your Honor.
Yeah, sorry. That's right. You understood what I just said. We're going to take a brief recess at this point, a little earlier than I'd hoped, and let the IT department try to get these telephone lines set back up again. Again, my apologies to you, Mr. Donovan. Sorry to interrupt your argument.
That's just fine, Judge.
I think we need to do that at this point. So we'll stand in recess for probably no more than 10 minutes or so. I don't know where the IT department will attend to this properly.
Thank you.
Oh, yes, Mr. Aronchek?
Aronchek?
Yes.
Your Honor, while we're on recess, the Pennsylvania Supreme Court just issued
I'm sorry, say it again, Mr. Aronchek.
decision. Yes. Can you hear me?
No, you're breaking up on me. Yeah, maybe move away from or closer to the microphone.
All right, can you hear me now?
Try it again.
Can you hear me?
Yeah, no, you're breaking up on me, Mr. Aronchek. I'm sorry. Why don't we do this? Let's see if we can tune you back in on a 10-minute break.
I have important information for you, though, for your break.
Yeah, go ahead. What is it? Do your best.
The Supreme Court, the Pennsylvania Supreme Court just issued a 5-2 opinion. In our case, it was my case, the observer case, saying that there was nothing wrong whatsoever about what Philadelphia did. All of the things that Mr. Giuliani was talking about has been ruled out 5-2. It was all acceptable. It was all proper. Maybe Your Honor could get the opinion while you're on break.
We're going to do that. All right, I'll repeat that. Mr. Aronchek, thank you very much. Let's check into Mr. Aronchek's line as well. That is going to be the nub of it is the Pennsylvania Supreme Court, apparently, according to Mr. Aronchek, has just ruled and issued a decision 7-2 that affirmed the lower court. I'm sorry, 5. I misspoke. 5-2, 7-member court. 5-2, affirming the prior decision. Is that the nub of it, Mr. Aronchek?
Saying that the observer issue is not illegal, not improper at all.
The observer issue is not an improper.
Correct, Judge. So it affirmed the trial court.
Affirming the trial court.
The Commonwealth.
I misspoke. Yes, it affirms the trial court versus the Commonwealth court, and that is in a 5-2 decision with a 7-member state Supreme Court, as you're probably aware. So I'll pull that decision up. I think that may have some. It may have some have some assistance to me as I make my determination here. So for those of you who are down in courtroom 3 or members of the public, we are taking a short break because there are some technical difficulties with those people who have dialed in on telephone lines, both members of the press as well as members of the public. For those of you in the jury assembly room, who I believe are exclusively members of the press, again, we're going to stay in recess, I hope not very long, to get these telephone lines hooked back up. So don't stray too far away. We'll be back momentarily. Thank you, counsel. Court will rise. All right, thank you. Please be seated. All right, we're back on the record. Again, we had, as counsel is aware, and the members of the media, and to the extent the public is present, we had the telephone lines go down for reasons that I don't understand. I'm told that they're back up again so that the public can participate in this oral argument by listening to it. So again, my apologies, Mr. Donovan. Go right ahead. You're sort of midway through your equal protection argument.
Thank you, Judge.
Pick up where you left off.
I will, Judge. Thank you. And where we were discussing was really why the allegations here do not establish a equal protection vote dilution claim. And I was on the campaign versus Boockvar case from the Western District, and just a couple more points, then I want to point to some other cases. But what Judge Ranjan said there in the Dropbox context, where they were saying it was unequal, right before star 44, he said what plaintiffs, they're the campaign, have really identified then are not uneven risks of vote dilution, affecting voters in some counties more than equivalent voters in others, but merely different voting procedures in different counties that may contribute different amounts of vote dilution distributed equally across the electorate as a whole. The court finds that this is not an equal protection issue, and I'd submit that's the same claim here. And finally, with respect to that, I come back to the end of that section from Judge Ranjan's opinion. He's citing other courts, but he says, it is well established that even violations of state election laws by state officials, let alone violations by unidentified third parties, do not give rise to federal constitutional claims. And then he goes on at the end, he goes, what they were alleging there, this type of equal protection claim fails as a matter of law. And Judge, I'd submit we're no different here. And at page 27 of our brief to the amended complaint, we cited the Judge Ranjan, but we also cited two other cases. I just want to give you the context to say. One is the Northeast Ohio Coal for the Homeless. And there, the Sixth Circuit rejected an equal protection challenge, even where the plaintiffs presented uncontested evidence that in determining whether to reject a given ballot, the practices of boards of elections can vary and sometimes considerably. In the 11th Circuit in 2006, Wexler, plaintiffs do not contend that equal protection requires a state to employ a single kind of voting system throughout the state. Indeed, local variety in voting systems can be justified by concerns about cost, the potential value of innovation, and so on. The point is, Judge, general complaints that whether there are differences between counties or that counties may have counted some ballots differently is not a federal court equal protection claim. And for that, Judge, I'd move on to slide 15 just to show you a couple other courts. Short v. Brann, the Ninth Circuit, and there they said, under the plaintiff's theory, unless California foists a new system on all 58 counties at once, it creates an unconstitutional vote dilution in counties that do not participate in the pilot plan they had there. Nothing in the Constitution, the Supreme Court's controlling precedent, or our case law suggests that we can micromanage a state's election process to this degree. No different here, Judge. And then slide 16, Judge. Two more cases I just want to tick off quickly. One is the Fifth Circuit recently, where again they said a law that makes it easier for others to vote does not abridge any person's right to vote. And this goes to the named plaintiffs, voter plaintiffs here. There it was the drive-through. Again, the July 27 and October 1 proclamations, which must be read together to make sense, are beyond doubt, or beyond any doubt, measures that make it easier for eligible Texans to vote absentee. How this expansion of the voting opportunities burdens anyone's right to vote is a mystery. And finally, Judge, the District of Nevada recently, there they said Clark County's plan to make it easier or more convenient to vote in Clark County, but does not have any adverse effects on the ability of voters in other counties to vote. Plaintiffs are unlikely to succeed on their claim of equal protection violation where they provide no evidence and cannot provide any that the Clark County plan makes it harder for voters in other counties to vote. Same thing here for the new, for the two voter plaintiffs. They said we couldn't vote, but nothing any county did, anybody did, made it any harder. They got to vote by mail. Unfortunately, they didn't do the secrecy envelope, and the Pennsylvania Supreme Court under state law said that's required, so they weren't counted. So where does that leave us, Judge? Well, where it leaves us is that the two named plaintiffs, as I said, they don't have standing, but they also can't make an equal protection clause claim because the fact that some counties may have taken some steps to tell people, hey, your mail-in vote's defective, you can vote provisional if you want, and we'll see if it gets counted, didn't impact them. They got the right to vote. And the same thing for the campaign that I talked about earlier, about what they talked about for the campaigns, right, the competitive advantage. And I just went through all these equal protection claims cases, including the campaign's case in the Western District. And there, what they can't show here is that any ballot that was counted affected any race differently on ballots, and it affected all candidates, and that's under federal equal protection law. So to wrap this section up, Judge, the Secretary fundamentally disagrees with allegations that the Pennsylvania Election Code was violated or there was fraud. In fact, it's quite a huge success during the pandemic that almost 7 million Pennsylvania citizens voted. But that's not an issue in this case. That's not an issue in this case. Suffice it to say, the plaintiff's allegations, as they've alleged in the First Amended Complaint, do not establish a federal equal protection clause that they can pursue, and it should be dismissed today as a matter of law. And Judge, I want to end my section before I hand off to Mr. Aronchek where you started today, Judge. There's one count in this case that's active. The second one's for appeal. Mr. Giuliani spent a lot of time on canvas, and I know the Pennsylvania Supreme Court has now ruled, so I think that's moot. But more importantly for our purposes, Judge, the red line the plaintiffs provided about the canvases, deleted. So, you know, I'm here on a motion to dismiss, so I think we have to take the First Amended Complaint. No standing, no equal protection clause claim, and they deleted the claims Mr. Giuliani talked about. And I want to add one final point. To say they don't have a federal equal protection clause claim does not mean there can't be challenges. I'm sure there are lots of, I know the campaign here did, they challenged on Election Day, they challenged after Election Day, they're challenging still in state court. That's to be decided by state court. But for our purposes, Judge, they do not have a federal, they don't have standing, and they don't have a federal equal protection claim. Thank you, Judge, for your time again.
Thank you, sir.
I turn to Mr. Aronchek next.
Mr. Aronchek, are you ready to proceed on the abstention issues? Mr. Aronchek, if you're speaking, I think you may still be on mute.
Am I unmuted now?
Let's try it again.
Am I unmuted now?
Yes. Can we turn him up just a little?
Okay, Your Honor.
Maybe could we turn you up just a little bit in volume, sir?
I'm at the highest I can be here.
That's
Do you
fine.
have a volume control?
Oh, you're good. That was good. Counsel, can you hear him?
Okay.
Counsel's indicating yes. You were good there just a moment ago, Mr. Aronchek. Go right ahead.
Thank you, Judge Brann, and thank you for the courtesy of appearing virtually. I appreciate that a lot. Your Honor, I was prepared and will address abstention, but because of a number of the items that Mr. Giuliani raised, because of some of the intervening case law from the Supreme Court, because of your questions that you raised, permit me to go through a series of other points briefly, and then I will get to abstention. The first thing I want to say is that there's a very, very important statement in Chief Justice Saylor's dissenting opinion in today's ruling. The ruling, of course, was 5-2, that observers are just that. They're not.
Mr. Aronchek, we're having some problems hearing you. Can they just a moment, Mr. Aronchek, just a minute. Can they put their screens up and see him? No, I suppose not. Yeah, pop them up if they can. That may help. Both. Hold on a second. I realize that seeing is not hearing. I appreciate their different senses, but somehow in my mind that helps. All right, go ahead, sir. You know this.
Thank you, Your Honor.
Virtual arguments have some difficulties, as you can appreciate. So do the best you can.
I do, and I hope that you can hear me because you're the important one.
I can hear you.
So the first point I wanted to make was that yes, the observer issue was decided decisively. The Pennsylvania Supreme Court 5-2, and you can see that in the majority opinion, and it eliminates, I mean, it really cuts out, I think, almost 90% of what Mr. Giuliani was trying to argue is involved somehow in this case. And I will address, I am sure Mr. Giuliani is going to then come up and say, you know, the Pennsylvania Supreme Court just committed some kind of an equal protection violation by saying that different counties can set up their ways of observation consistent with their local needs differently. I just want to say, I'm sure he's going to say something like that because he's very inventive. He just keeps moving on. But on this particular issue, two things. Number one, there is no constitutional right to be a poll watcher observer. That's settled. That's in Judge Ranjan's opinion. That's in the Pennsylvania Supreme Court's opinion. There is no such right. It is a creature of state statute. The Pennsylvania Supreme Court has just told us what it is. And end of story. Mr. Mercer and all of Mr. Giuliani's supposed witnesses had their right to observe, and they had nothing to challenge anything. They had a right to see what was going on. They did see it. That's over. That can't be hijacked into an equal protection case. But number two, Chief Justice Saylor, a great Chief Justice, by the way, said in his dissent on page 2, it's important, finally, short of demonstrated fraud, the notion that presumptively valid ballots cast by Pennsylvania electorate would be disregarded based on isolated procedural irregularities that have been redressed, thus disenfranchising potentially thousands of voters, is misguided. What the Chief is saying there is that the kind of thing that Mr. Giuliani is asking, wipe out the mail-in ballots, suppose that a couple of handful of irregularities, is misguided, not available, not happening under Pennsylvania law. Now, that's the first point I want to address about this observer opinion, very important opinion. Second issue, I don't think that Mr. Giuliani has even read Judge Ranjan's opinion or even understands it. It wasn't addressed by Mr. Giuliani in his argument. It was not addressed at all in any degree by the brief that was submitted to Your Honor yesterday or the day before. Judge Ranjan, if you step back, Your Honor, had before him an even better version, a better pleaded version of the same theoretical thing that they are now arguing about the notice and cure issue. And what I mean is this. In that case, in their 200 paragraph allegations in that case, they like 200-page allegations, they put into that case all sorts of elements of fraud. Not in this amended complaint, Your Honor, not here. But there, they tried to say, look, in the primary election, we had this kind of fraud, and this kind of Dropbox fraud, and this person had 2 ballots in their hand, and they showed all kinds of pictures. More pictures, and frankly, better pictures than the ones Mr. Giuliani is waving around now, largely irrelevant because of the Supreme Court's opinion, by the way. But in any event, pictures. And he said there's all sorts of fraud and susceptibility of fraud. They also said that if you allow these drop boxes, which are susceptible to fraud, some counties will have them because it will make voters' experiences easier in a pandemic, and other counties may not. And that's an equal protection violation. Your Honor, it's the same thing here. They tried to say in the first amended complaint, 33 times they said, there are allegations of fraud. They took all 33 out of their amended complaint. Mr. Giuliani is talking about another case, not the case before Your Honor, some invented case, some fantasy world. But the case before Your Honor, they removed all the fraud allegations. One. Even if they're left in, Judge Ranjan showed the way here, and I know we respect him, we respect you. You're independent of Judge Ranjan. I understand that. We're in the Middle District. But he showed you in painstaking detail how he went through each of their fraud allegations and rejected them. This picture doesn't say what you said it said. This picture is distorting. There are no fraud allegations. And then what else he said? He said your effort to go bring in history about something that happened in 1960 or 1993 or 2001, somewhere else or someplace that amounted to some kind of fraud doesn't belong in this case because the case law that he cited says you don't go back to those kinds of things to talk about susceptibility to fraud in present day, real-time common elections. That was all amendment under the case law. Now, what else did he say? He also said variations on uses of drop boxes, that's okay, because there is a legion of case law. Some of it Mr. Donovan directed you to, that says that variations on the administration of an election, county to county, are not equal protection violations. And what's more to the point, what's in this case? The variations that Judge Ranjan faced, that you face, are variations where some counties have the ability to make voting easier in a pandemic. All counties had that choice, uniformly, across Pennsylvania. All counties could have done it. They could all use drop boxes. They could all have a round of notice and cure. They all could have done the same thing. The fact that Mr. Giuliani's favorite counties didn't do it doesn't mean it's not available, and it doesn't mean it's an equal protection violation for the counties that did do it. There is no case that they have cited. There is no case that we can find where efforts to make voting experiences easier, even not in a pandemic, but now, particularly in a pandemic, is an equal protection violation. What they are doing, as Judge Ranjan said, is inverting the Equal Protection Clause, turning it upside down. They are saying, go to the counties with the lowest level of administrative experience, whatever they tried to do for the voters, for whatever reasons, I'm not saying it's bad or good, but whatever the lowest level of running the election is, whatever the lowest level of opportunities to make voting easier, they chose. In Mr. Henry's case, Lancaster didn't tell him about notice and cure. It was in the law. He had the opportunity. He should have known it. He believed it when he put his vote together, but they didn't tell him. And Fayette County apparently didn't tell Mr. Rogers. Okay, but we don't race to the bottom now. We don't say that our measure is the lowest common denominator of whatever any counties did. That is not equal protection violation. That is not a rational basis decision. That is nonsense. Total nonsense. It is not recognized by any law. And more to the point, Bognet, a 3-judge panel, Chief Judge Brooks Smith, former Chief Judge Sirica, Judge Schwartz, not from Pennsylvania, by the way, from New Jersey. They wrote a panel decision, unanimous, that said the kinds of claims that Mr. Giuliani is peddling here today that amount to equal protection violations just don't. And they went back 80 years to the Pennsylvania, to the Third Circuit decisions in 1944 that said the same thing. And you know, if you look at Bush versus Gore, all 9 justices said the same thing. We're not talking about differences or problems, or even if they're wrong in the administration of elections and the counting of votes. That's not an equal protection violation. That's not what Bush versus Gore is all about. That's not what Bognet is all about. That's not what Judge Ranjan was all about. That's not what anybody has been all about. So let me just put that equal protection issue over here for a second. I want to underscore what Mr. Donovan was saying to you. The cases he proposed to all say the same thing. The Short case, the Husted case, the Northeast Ohio case, one after another in the current environment as well. Now, number 2. Mr. Giuliani talks about when he went to law school, he heard about cases and controversies, and he remembers from his first year law school class something about standing. But what he doesn't remember is how standing actually is articulated in the case law, including in your case, which he didn't even address. Your Voters Alliance case, which our firm was involved in. We were involved in all these cases. He didn't even bother to address your own standard, in your own opinion. But let's put aside that for 1 second. I believe that we have an actual complaint in front of us, a First Amendment complaint. We don't have an invented story, as Mr. Giuliani came here with, about 10 other states, about Clark County, Nevada, about something that happened in 1960, about Ozzie Myers, about the mafia in Philadelphia. He called our election workers, our patriots, our people who run the elections, the mafia. I mean, this just is disgraceful in an American courtroom of any place, including in the federal district court. But put aside the invention and let's look at the complaint. Not the one he thinks he's going to amend later on. He has no right to a Second Amendment complaint, by the way, Your Honor, under the rules. There is no right to do that. But let's look at what's here. And let me direct you for standing purposes, Your Honor, to the actual allegations in this complaint. That's where the analysis starts. In count one, they talk about notice and cure. By the way, a minuscule problem, not affecting any amount of votes that matter here. But let's just take their claim. They say notice and cure is an equal protection violation. Well, what are the facts you have to look at, Your Honor, in order to measure standing? Out of 150 allegations, there's 8 vaguely worded allegations, giving them the benefit of all the doubt. 8 vaguely worded allegations that address what they think are problems about notice and cure. Let me direct Your Honor to them so that you can study them later. In paragraph 129, told that on November 2nd, Secretary Boockvar told all the counties that they can give lists of rejected mail ballots. They can give them out to everybody. And they can advise parties, candidates, and voters about the list of rejections so that voters would know and could have the opportunity to exercise their right to spoil their ballot and vote in person or provisionally, vote on the machine in person if they're allowed, or provisionally if there's some issue. This is paragraph 129. I say, hallelujah to Secretary Boockvar. I mean, what in the world is wrong with telling all the counties that they could advise voters that their mail-in ballots were rejected so that they can go to the polls and exercise their rights under 25 Prudence 3950, paragraph 16, paragraph B2, which is they can score their ballots and vote in person if the if the system shows that the ballot was spoiled, or provisionally if it's not yet in the computer. That is a problem? Hardly. Number 2, paragraph 127, they say Philadelphia did that. They say hallelujah. I mean, what's wrong with telling voters you have a right to vote? Your mail-in ballot didn't work. I mean, I feel really bad for Mr. Henry and Mr. Rogers that their counties didn't bother to tell them. Not so bad that they didn't follow their own instructions. Not so bad that they didn't know the law themselves. But so what? Paragraph 130. They say 4 counties chose not to tell the voters what the secretary said all counties could tell them, and what Philly did. Those 4 counties: Berks, Westmoreland, Lancaster, and York. You know, I don't know, and you don't know, and nobody knows from this complaint, what did the other 60 counties in Pennsylvania do? Mr. Giuliani waves his hand around. Somehow he must have some superior knowledge, but if he does, it's not in their amended complaint. It's nothing you can do anything about in evaluating the strength of this complaint is against standing. Paragraph 15 and 16, that talks about Rogers and Henry had their problems because they didn't do it right, and nobody told them that they had another chance. Paragraph 124. This is the one that for standing purposes is amazing that it's in this complaint and that they still are asking you to say they're standing. Because standing involves, as Your Honor knows, in your opinion, a few things. One of which is concrete particularized harm. But the second is harm particular to the person complaining that is traceable to the problem that is being alleged. They say in paragraph 124, apart from the notice that I guess even Philadelphia, that's what they know about here, gave, although they try to act as if there's some cabal or mafia among Democratic counties. I mean, ridiculous. But apart from the notice that Philadelphia gave, they say, essentially here, you can read it, there's a huge public service campaign and media announcements and all sorts of information to the public that you have to be careful about filling out your ballots right, your declaration, having no naked ballots, make sure they're signed, make sure that you have the secrecy envelope. An enormous public relations campaign. Now, these unnamed voters who they don't talk, I mean, these people that they're worried about that bothered to cure their ballot or bothered to vote provisionally so that they could exercise their franchise in this important election. How do they know why these voters went and did that? How do they know whether these voters listened to the public service announcements? Listened to candidate President Trump, who told everybody, don't vote by mail. Vote in person. How do they know why these voters who went and spoiled their ballots and voted provisionally actually voted? They have nothing in here that traces the supposed harm to the individuals that they are complaining about. Nothing. And they're leaving it for you to speculate about. And that is not a federal complaint. That is not standing. That is not jurisdiction. That is not a case in controversy with whatever law school we all went to. And in paragraph 97, as my colleague, Mr. Donovan said, they say, well, there was vote dilution from the people who went and cured their ballots or voted provisionally. Well, if there was, there's no specifics. There are no numbers in here. You have no basis to judge, to figure out what is in front of you from this complaint. But even then, back to Judge Ranjan, back to the Bodnet decision, back to every decision that deals with this loose concept of vote dilution. If it is dilution, if it is a problem, if there is a state law violation that somebody's vote was counted improperly, it affects everybody else, not just one person, everybody equally. And that is a generalized grievance. That is not standing. And then they say in the last of these handful of paragraphs, paragraph 131, well, as a result is President Trump lost votes. They just want you to accept that. But there's nothing in here that they can establish that that happened. How do they know that the people, the few people who went and voted provisionally, or that spoiled their ballots and voted provisionally, the very few were cured, how do they know who they voted for? How can you know? Redressability is part of the issue. There's nothing in this complaint, nothing that says that these claims, whether it's by the individuals, whether it's by the campaign, have any basis of redressability, other than Mr. Giuliani's notion that let's just throw out 680,000 votes, which, by the way, because observers couldn't see things. By the way, that is what the Pennsylvania Supreme Court just said you can't do under Pennsylvania law. But common sense, Your Honor, would say that you can't do it based on this complaint. Can you imagine anybody understanding a court order canceling 680, or up to now, I get from Mr. Giuliani, 1.2 million votes based on nothing in this amended complaint? Can you, I mean, the idea that you are being asked to do that, honestly, Your Honor, I don't use these words very much. I argue in court a lot. It is disgraceful that you're even being asked to do that. That is not, whatever. And so, that's it. That's it. So when we talk about standing, we don't know anything that's important from this complaint. Anything. I just went through all of that. Let me get even more fundamental about this, and that is this. This complaint is, at its core, at its essence, a small ball complaint about a certain kind of procedure that the Secretary said is available to counties. A limited procedure that if the ballot wasn't signed, come in and sign it, and then we'll put it into the system for canvass. Now, how does that come about as a matter of state law? Here's how it comes about. Under state law, to give the citation, 25 Cordons 3150 16B1. There is an activity that happens before the canvass and pre-canvass. Mr. Giuliani didn't tell you about this. That activity is that the Board of Elections are supposed to prepare a register of all of the votes that they are going to count, that are going to put into the counting system, the canvassing system, on the mail-in votes. They have to prepare a register. So when they're doing administrative work to prepare that register to put it into the pre-canvass and the canvass, they naturally are looking at the mail that came in. They're not opening it. They don't know who voted what. They look, hey, here's one, the declaration. Oh, this isn't signed. They have sophisticated machinery now that Your Honor knows about from the Voter Alliance case, that they were complaining, oh, it's so terrible that there was funding for counties to have sophisticated machinery to move the counting along, but they did, and this sophisticated machinery has the ability to weigh the ballot that's coming through. And if it doesn't have a secrecy envelope, then it's going to weigh less, imperceptibly less, but that's how good the machinery is. And so, oh, yeah, this ballot apparently doesn't have a secrecy envelope. We can't open it. We're not going to open it. So we're going to hand it out. We're not going to put it on the register. That is the administrative function that counties do. Now, along the way, some of the counties developed small numbers of votes. These are not big numbers. And told voters, we're not going to put your vote on the pre-register. This is before Election Day, days before. You know you don't want to vote in person because of the pandemic. Perhaps that's why you voted by mail. We're not going to make you go and vote in person because of the pandemic. We're not going to spoil that ballot. And you're going to spoil that ballot and vote in person. We're going to tell you, if you want to come in and sign it, sign it. We're not going to look at it. We don't know if you're a Trump voter. We don't know if you're a Green Party voter. We don't know if you're a United voter. We don't know. But come in and sign it. And all voters equally have that opportunity. And some voters took advantage of it. Not many. Now, the second thing that happens is, there is a canvass. And at the canvass, they're evaluating these votes. Are they filled out? Is there a defect? What's going on? And some voters either knew about their rights, heard it on the public relations information that they plead in their complaint. I'm not going outside of the complaint, not like Mr. Giuliani. I'm staying in this complaint. That's what they pled. And they went and voted provisionally. Okay, so what? But here's the thing. If there's anything wrong about that, and this gets to the question you asked me, Mr. Donovan punted to me that you asked. There are state law remedies and procedures to challenge at the county level, county by county, whether they do or don't, or should or shouldn't count that vote. And on page 10 and 11 of our brief, we listed the cases that we asked about, that we knew about at the time last week when we said in that brief. Since then, there is apparently an Allegheny County decision. There is I believe, a Chester County, a Bucks County decision. And these common pleas decisions, board of election decisions and common pleas decisions are moving through the system, as they should. And a new development is that we filed last evening, at King's Bench. Here's what happened. The Commonwealth Court took the Philadelphia cases, consolidated them together, and set them down for argument on Thursday. And these cases are dealing with general challenges of all sorts to the mail-in ballots at the county level. And again, not many, when you look at the votes, not many votes, and I'll address that in a second, but nothing that's going to affect the outcome of the election. Nothing, not even close. Not the number of votes that are in ballot, not even close. But the Commonwealth Court consolidated those cases, and they set it down for argument on Thursday on looking at the stand, what happened in these Philadelphia challenges. A total of about maybe 8,000 votes in Philly, completely, that are under challenge of the Commonwealth Court.
Sorry, how many?
And about 8,000. I believe it's about 8,000. I'm giving you round numbers. I can give you precise numbers afterward, but I'm giving you round numbers. I believe it's about 8,000. That's the order of magnitude. And last night we said, look, these cases are going to percolate from other counties. Pennsylvania Supreme Court, would you be available to take the King's Bench? Because November 23rd is right on our heels here. If the Commonwealth Court makes a decision, then there's going to be an appeal, and it's going to be Sunday, and you're going to be hearing this. So how about King's Benching? And it's under advisement right now, Your Honor, and they want an answer to the King's Bench petition at 5 o'clock. Is it 5 o'clock yet? In a half hour. They want an answer, and I guess they'll decide whether they're going to take this particular challenge up as a King's Bench. So, that's what I know about right now about the county things. But there's one point I want to address about that, and that is this. Judge Mongin, it's going to get to some points I want to make about abstention, but it comes up here logically, and I just want to point this out. Judge Mongin was facing the same kind of an issue with drop boxes and whether signatures were even required under the on mail-in ballot declarations. And he said, I'm going to abstain under Pullman and Younger, and I'm saying to you, Trump campaign, because it's the same campaign, I'm saying to you, Trump campaign, he wrote this, you have state remedies. This is way before the eve of certification. This is in August. You have state remedies. There are cases pending. You can go intervene. That's your choice. You can bring a new case. That's your choice. But you need to do them. Don't ask me, because the kind of claims you're putting on my doorstep are equal protection claims based on state law violations. And I want to know from the authoritative courts, what are state law violations you're talking about here? Now, same thing here. And one case to dwell on is the Ham case, which we put in page 10 and 11 of our brief. The Ham case, which is before Judge Brobson in Commonwealth Court. That was a challenge by some voters, different parties, about the ballots and whether you can spoil and whether you can vote provisionally. The main thing that they're in this small complaint that they're trying to dress up as something big before Your Honor, the main piece of it is about whether you can spoil your ballot and vote provisionally, believe it or not. That's the main piece. And Judge Robson said, look, okay, I want Philadelphia, the county that was counting these, to segregate those ballots. Go in and out, but segregate them. And there were 593 ballots segregated. 593. This is the order of magnitude we're talking about. Segregated. Now, maybe that would come back to Judge Brobson. The case is still open. But here's the thing about abstention. The Democratic Party intervened and was granted party status. The Trump campaign knows about that case. They didn't intervene. They could have. Judge Ranjan told them in the summer, if you can, do it. No. Instead, they wanted to dress up that issue for you and ask you as a federal court to audit this election, to collaterally sideswipe this election, to act as some kind of superior appellate court over the state courts, a Rooker-Feldman problem. That's how they came about doing this. They did not choose the logical correct path under Younger and Pullman. Instead, they come running in here, and they don't even talk about the complaint that is before Your Honor. Mr. Giuliani is talking about something that is not before Your Honor. Not before Your Honor. So let me go back to abstention. There are so many ways and cases and authorities on this point, I don't even know where to start. Judge Ranjan put a lot of them together. It starts with Pullman and Younger. Is there something or something that could be pending, basically, is what it means. And the fundamental question is the one I said before. Is it okay when they're compiling a register of absentee votes and they see problems to let voters know so they can come in and correct the problem and not have to go into the polling place on election day and many voters can't and don't want to, and that's the issue. It is up to them. It's their burden to show you why they can't go or didn't go to a Supreme Court, a state court rather, and get a ruling on that issue. I mean, they presumably still can, but they didn't. And that, you know, if anything, Your Honor, I'm urging you, I'm pleading that you tell them just what Judge Ranjan told them. I am not getting involved. You had, and if you waive them, that's too bad, or have whatever opportunities you can think of to go to the state court and get a ruling on your question. You know, there is an opportunity now, still, under the election code, there are contest provisions that they can raise up to the day of certification. That they may not, they are heavy burdens. They are the ones that Judge Diamond faced in the Stein case in 2016. I will address that in a second. They are there, but it is too bad on them if they don't like what the election code is provided as their remedy, because it's too hard. It requires actual evidence and not a lot of hand-sweeping statements about hearsay affidavits in Nevada or anywhere else. They have to put real evidence in the contest petition, and they have to show real numbers of votes that are affected, and they have to put up a real bond. But that is available to them if that's where they want to go. And that is why abstention is so important. You know something, it's abstention on steroids. And here's why. What you have in front of you is not only Younger and Pullman abstention, it's abstention on legal steroids. Here's why. Look at what Judge Diamond said in the Stein case. Stein case is very instructive. In 2016, Jill Stein was the Mr. Giuliani today. Jill Stein was the one who came in with all sorts of hand-sweeping allegations about hacked voting machines and all sorts of pervasive fraud around the Commonwealth and in the world and in the universe. That was Jill Stein then. And Jill Stein, unlike the Trump campaign today, at least went ahead and filed a contest petition. And then when she was faced with $1 million bond, decided, whoops, I'm going to go to federal court instead. Sort of what they're doing here. In other words, in 2016, Jill Stein is Trump today. the Trump campaign today. In 2016, the Trump campaign was us today. The Trump campaign said, no way, Ms. Stein, abstention. Get out of federal court. Your case doesn't belong in federal court. It's not an equal protection violation. It's an abstention problem. That's what they said then. They were right then. They're right today. Same campaign, different action. And we don't play fast and loose with federal courts. And on that point, Judge Diamond said the following. This is why I say it's abstention on steroids. Judge Diamond...
Mr. Ehrenreich, again, we're having maybe some difficulty hearing you. I don't know what we do to improve that. It may be, and I don't say this disrespectfully, maybe you're moving around too much.
Okay, I don't think so, but I don't have a lot more to do it. I'm sorry. If I'm moving around too much, I'll keep it.
All right, try not to move. Are you looking at me?
I will.
I'm not moving at all. Just if you follow me, I'm not moving. Once in a while, I'll prop in a characteristic Brann move. Doesn't mean I'm bored. It's just I picked it up from my father, I think. I'll put my fingers to my head. That's as much movement as you're going to get from me. So you might want to model that and see if the voice improves. So in characteristic gesture, I'll go like this. I won't move for you.
I'm going to stay right at your glasses and not avert my face.
I'm staring right at yours. The camera is here. I'm looking directly at you, believe it or not. So don't move. Your lips.
I'm not going to move. My lips are moving, but Your Honor, I want to know if you got all my eloquence already, or do I have to go back over any of it?
Oh, no. Let's pick up where you left.
Okay. All right. So what I'm going to say about Judge Diamond is this. Judge Diamond said, wait a second, we're in a presidential election. And abstention means something even bigger. It actually means comedy. It actually means deference, and here's why. It means dismissing the whole case, not waiting for something else to happen. And here's why. Under 3 U.S.C. Section 5, Congress has said that we will leave to the states to set up their election code with their county regime, with their administration, with their remedies. And we will expect that will fit with the constitutional imperatives and the statutory imperatives of making sure that by the safe harbor date, the governor is able to certify a slate. Now, that is the last act, but the first act is November 23rd. That's the first set of certifications. And the Pennsylvania election code set that up, provided for remedies, whether the Trump campaign likes them or not. Those are the remedies. And Judge Diamond said, we need to honor that. We have a presidential election. We need to understand that we have to have electors certified by the governor by the safe harbor date of December 8th. We need to move backwards from that. And we are not countenanced, Judge Diamond said, in strong language. Federal courts, the use of federal courts, on any but the most extreme equal protection violations, upsetting that calendar, no matter what you want, Phil Stein, and I would say no matter what you want, President Trump. And those most egregious violations of equal protection are the ones left by Chief Judge Smith and Godnet. Pervasive fraud, not here, not in this complaint, not before you, 33 counts removed. A systemic breakdown of the system, where a hurricane blows out a whole system. How many votes were involved? And you come to court on that kind of extreme situation. Bush versus Gore, which is not, as they said in their own opinion, what this case is all about, or the mine run of efforts to try to go to federal courts. You don't have that in front of you, Your Honor. And so I would say, just like Judge Diamond, you have a half a dozen right significant ways to dismiss this case. There shouldn't be a hearing. There's no need for a hearing. You can already understand what kind of circus that'll become. Mr. Giuliani previewed it. We're going to hear about Nevada, 10 states, stacks of unverified affidavits that he's going to look for special ways to introduce, all kinds of things based on nothing. And so I urge, on behalf of the counties I represent, dismiss this case. Please dismiss this case so we can move on to the real business of this country. This case for some reason has become a lifeline to the Trump campaign. Please, we need to move on. We need to get this election certified. We need to do it the way the election code says we need to do it. And I urge you, please, to enter that order. Enter that order, and that is it. That's all I have to say, Your Honor. I hope you heard it all.
Good. Thank you, sir. Now, I'm going to turn back to Mr. Donovan for a moment just to orient the court. Do you know, Mr. Donovan, what other defense counsel would like to speak? Do you have anything else you'd like to add?
One moment, I'll confer to see if
That's, well, I can do a little round robin with them, but I'll let you go ahead first. We're going to take one momentarily. Yeah, momentarily.
So, Judge, my understanding is two of the interveners want to address you very briefly on these three issues, and then
all right.
I'm happy to answer any questions for the defense.
Right. Well, I'll have some questions. Why don't we do this? I think some counsel have asked for a short recess at this point, so let's take about a 10-minute recess. It's now 4:45 p.m. Let's stand in recess until 4:55. For those of you with the press, we're going to take just a 10-minute recess. We'll be back on the bench. I'm sorry for the other recess went as long as it did. As you may or may not appreciate, the telephone lines for both the press and for members of the public were down, and that had to be squared with AT&T. This is an ordinary recess of 10 minutes. Again, for those of you who are viewing from Judge Arbuckle's courtroom on the third floor, again, the court will stay in recess for about 10 minutes, then we'll resume the argument. Or rise.
All right.
All right, Mr. Donovan, you signaled that two of the counsel representing the intervenors wish to make some commentary to the court.
Yeah, Judge, one amendment for Center County Counsel has about 2 minutes. She'd like to address an issue if she could before we go to the interveners.
That's fine. So Ms. Dupuis or Ms. Beach, Mr. Dupuis?
Your Honor, thank you, Elizabeth Dupuis for Center County Government. Center County joins in the standing and abstention arguments stated previously, but additionally, based upon the allegations both in the amended complaint and the proffer of evidence in the plaintiff's opening argument, Center County did nothing wrong. The plaintiffs do not put forth any concrete facts in the complaint which show a violation of law as to Center County. We know from the PA Supreme Court decision that the manner of handling pre-canvass is a county decision. Looking at the complaint as to Center County handling of the pre-canvass, which the plaintiffs correctly note was in a ballroom, which was live streamed on the web, and more importantly, all candidates and parties had full access to the room during the 2-day period. Additionally, no complaints were made by either party or campaign to Center County. The other matter in the complaint is an unspecific allegation that a voter, not identifying the voter or the precinct, we have 80+ precincts in Center County, received a provisional ballot. If the same were true, per the election code, the challenge to that ballot should be handled through the provisional ballot process, which is under the Pennsylvania election code. Again, the issue of abstention. The plaintiff campaign team was present the entire time that Center County reviewed provisional ballots and raised no objections to the process, nor were any provisional ballots in Center County challenged. Center County is entitled to a dismissal of this complaint against it based upon both standing and abstention and the failure to state a claim.
Thank you, Mr. Booth. And Quanta, I believe. Remind me, sir, who you represent again?
Zolman Quanta on behalf of the DNC, Your Honor.
Okay, yes, thank you.
Good afternoon, Your Honor. I'm here to make a few quick points about some of the arguments that have been raised that I believe are dispositive to this claim, to the case that have been brought by plaintiffs, and I will make every effort not to repeat arguments that have been made already. First, I want to start off with the injury that plaintiffs have alleged. Plaintiffs have actually disclaimed any vote dilution injury on page 4 of plaintiffs' opposition to defendant's motion to dismiss. It states, yet plaintiff's injuries do not turn on vote dilution, but rather vote denial. That is in the beginning of the second paragraph of page 4. And the reason that is instructive here and the reason that is dispositive here is because a vote denial injury is not traceable to any defendant in this case. The plaintiffs in this case are from counties that are not listed as defendants here. Lancaster and Fayette County are the appropriate defendants in a vote denial claim. A vote denial claim alleges that some party improperly or unconstitutionally denied an individual the right to vote. None of the defendants in this case have done that. And when it comes to the Trump campaign, as Mr. Donovan has spelled out in detail, the Bognet case makes clear that individuals, whether individual candidates or campaigns, do not have standing or a right to enforce the general code and enforce the election code generally. These individuals have to demonstrate that the procedures that they seek to challenge and the potential election law violations will actually affect the outcome of the election. And the Trump campaign has not even made any such allegation that has occurred. Next, I'd like to point to the equal protection arguments that have been asserted by plaintiffs and the claims and allegations in their amended complaint, only to highlight that the main source of their authority, Bush v. Gore, actually counsels against the rule that they seek here. In Bush v. Gore, the court never recognized or endorsed the rule that every single locality has to provide uniform voting procedures. Quite the opposite. In fact, it's unclear what jurisdiction's election code would survive under such a rule. And it would lead to a breathtaking expansion of the Equal Protections Clause. And I want to quote from Bush v. Gore just to make sure everyone in the court is aware of what was at stake. The court said, the question before the court is not whether local entities and the exercise of their expertise may develop different systems for implementing elections. That was not the question before the court. Rather, the state court had implemented a procedure and had the authority to implement uniform procedures, but failed to do so. And that was the issue that the Supreme Court confronted in Bush v. Gore. Now, the Supreme Court also made clear that an overly rigid application of the Equal Protection Clause undermines the state legislature's decision to delegate to local authorities. So, Pennsylvania law does not have a supreme election judge that tells every single county exactly how to run elections and whose decisions are binding on every single county. Rather, Pennsylvania law delegates that decisions such that elections are run by county boards, and county boards have the power to make and issue regulations, instructions not inconsistent with the law as they may deem necessary for the guidance of election officers and electors. That's in 2642F. That type of delegation is contemplated not only by Pennsylvania law, but was contemplated by all 9 justices in Bush v. Gore. And there has not been a single case yet that has suggested that such differences in administration of election procedures can somehow trigger an equal protection violation. Lastly, I want to address briefly some of the allegations of voter fraud that have been asserted in this courtroom but were not included in the complaint. And specifically with respect to Mr. Giuliani's accusations on behalf of the Trump campaign. Because as the court may know, the Trump campaign is a plaintiff, or at least a petitioner, in several lawsuits in state court challenging decisions of county boards during the canvassing process. And in some of those appeals, the attorneys for the Trump campaign were specifically asked whether they were asserting that the ballots that were being accepted were cast fraudulently, or whether they had any information to suggest that there was fraud in the election. So, for instance, in the Montgomery County appeal, the court conducted a hearing on November 10th, and in that hearing asked counsel for the Trump campaign whether they were alleging that fraud had occurred. In response, counsel stated, accusing people of fraud is a pretty big step, and later stated, everybody is coming to this with good faith. The DNC is coming to this with good faith. Again, the court asked, are you claiming that there is fraud in connection with the 592 disputed ballots? Counsel for the Trump campaign stated, to my knowledge at present, no. That was on page 11 of the Montgomery County transcript. I know that transcript is not before the court, is not in the record, but nor were the allegations asserted by Mr. Giuliani. The DNC is happy to provide that transcript, but to the extent that those allegations do come before the court, or the court decides to consider them, the court should also consider these statements made by the Trump campaign's attorneys before state courts. I'd like to also highlight a hearing before the Philadelphia Court of Common Pleas, and I believe Ms. Kern participated in this hearing. And in that hearing, the court asked similarly whether Ms. Kern was alleging voter fraud with respect to the challenge ballots. And Ms. Kern answered, I am not proceeding on those allegations. She repeatedly, throughout the transcript, made clear that she was not asserting any claims of voter fraud. So the allegations that you have heard today, that is not the position that the Trump campaign has taken in state court. And if there were anything that confirms this, I will point to, and this is actually on the record, the order issued by the Montgomery County Court of Common Pleas. It was actually filed as an exhibit to one of the interveners' briefs, and the docket number is 142-1, page 3, and it's I think halfway down the page. And I'll read this excerpt. It states, the court heard oral argument on November 10th, 2020. Petitioners, being the Trump campaign, stated they were not claiming any voter fraud, undue or improper influence regarding the challenge ballots at issue. That was in the court decision because that was a concession that they had made in the state court. And there's a reason why they made that concession. The reason is because all of these challenge procedures, whether it be poll observers, the ability to cure, they affected Democrats and Republicans equally. Democrats were not able to stand over the shoulder of County Board of Election employees while they were counting ballots, and nor were the Republican observers. And it's particularly telling that the ballots that plaintiffs complain of and that plaintiffs claim were subject to fraud included a number of other races, some of which went for Democrats, some of which went for Republicans. For instance, the Auditor General, the candidate in the lead, is a Republican. The State Treasurer, the candidate in the lead, is a Republican. Now, these are statewide races. These are on the same ballots that the presidential race is on. So if these races are on the same ballots and the Republicans are in the lead, then where does that leave the theory of fraud in Democratic counties, or the theory of a fraudulent conspiracy conducted by Democrats? I think what this shows, Your Honor, is that plaintiffs' concerns and what they take issue with is not the ballots, it's the voters' choices. And that is why this complaint needs to be dismissed. Thank you.
Thank you, sir.
Good afternoon, Your Honor. David Zients for the voter interveners, NAACP and the other organizations and individual voters. Your Honor, I promised to be very brief and to not repeat anything that you've heard, but we do think it's important to bring this back to the voters. The perspective of the voters who, what's at stake is whether we toss out thousands or perhaps hundreds of thousands or perhaps we've heard millions of lawfully cast ballots. The first quick issue I'd like to discuss is the doctrine of latches. I think we have agreement from the plaintiffs at page 10 of their opposition. In the Third Circuit, latches can be applied at the motion to dismiss. I also don't think the plaintiffs have disputed that this is a particularly important principle in election litigation. We've cited case after case. There is a basic fundamental rule. If you can challenge election procedures before the election, you must bring that challenge before the election. This isn't some kind of technicality. In this case, illustrates exactly why this is so important. And it's important to protect the voters. What the plaintiffs are asking for is to toss out votes, is to disenfranchise people. But if plaintiffs had acted earlier, when they could have, we wouldn't be having that conversation at all. Plaintiffs could have come in, said, we're concerned that some counties are not making the same level of effort as others to help voters correct their ballots. Okay, so if they had said that, we could have, that's not an equal protection violation for the reasons that you've heard, but suppose that it was. There could be a tailored remedy, and perhaps the remedy would have been, well, Fayette County, you need to bring yourself up to the standard so that you are getting the same, Plaintiff Henry and Plaintiff Roberts are getting the same opportunities to correct valid ballots. We would never have been having a discussion about should we toss out thousands or hundreds of thousands or millions of votes. And that is the inherent prejudice of waiting till the last minute and really beyond the last minute. Can you solve a problem? Can you fix these alleged irregularities before the voters go to the polls, before they cast their ballots, and never even have a conversation about should we be discarding votes that have already been cast? So the question is, prejudice is clear. Could the plaintiffs have brought this challenge earlier? The answer to that is clearly yes as well. These notice and cure practices are not some arcane issue. This was well known. I think it's clear the plaintiffs in their complaint cite information about this that was available before the election. The court could just decide this on the basis of the complaint, but as sort of icing on the cake, we've attached a judicially noticeable document as Exhibit D to our motion. It's an October 15th report from CBS Harrisburg, not something that would be hard to find. It ran a report that began, quote, "Will you get a second chance if you made a mistake on a ballot, on a mail-in ballot? Well, it may depend on where you live." It may depend on where you live is the exact equal protection theory that we've heard in the amended complaint. It's the exact theory that we heard this afternoon. If plaintiffs thought that was an equal protection violation, on October 15th, they could have come into court and done something about it. The one thing they say in their opposition for why they couldn't do that, well, votes hadn't been counted yet, so the injury wasn't right. That can't possibly be correct because we know that plaintiffs went to Judge Ranjan over the summer and in the fall complaining about very similar mail-in balloting procedures. And the issue of ripeness was litigated on October 10th. Judge Ranjan issued a decision where he said, this is right because otherwise you would have to wait till after the election. So yes, your harm is imminent and you can challenge this now. That was October 10th. So of course, plaintiffs could have come in well before the election if they thought this was a problem. They didn't as a result, and only because of that delay, we're talking about casting aside thousands or hundreds of thousands or millions of votes, and that just can't possibly be correct. The doctrine of latches applies and is another basis among the many others that you've heard already for dismissing this complaint. Just to say one word about the proposed second amended complaint that we've heard about, that would just add to the prejudice and add to the delay. If we're now a couple of weeks after Election Day, we are coming upon the county's deadline for certification, the safe harbor date for the Electoral College. Putting aside the Electoral College for a minute, if there aren't certified results in Pennsylvania by the end of this month, there essentially is no Pennsylvania State House. There are no elected members of the Pennsylvania State House. So the idea that after all of this delay, something that easily could have been litigated before the election. To now say we're going to take 2 shots at it and actually we need a 3rd amended complaint a couple of weeks later, the prejudice from that, it just compounds and compounds. That's all I wanted to say about latches. Just one final word about the remedy that we're hearing about getting rid of votes. And the refrain that we've heard, I think it's paragraph 1 of the amended complaint, is we want to count the legal votes and don't count the illegal votes. But when you drill down to it, no one is talking about illegal votes. We're talking primarily about what's being called notice and cure. Think about the word cure. A ballot that is cured is fixed. It's legal. It has done everything. It has done everything right. The plaintiffs are complaining that some counties did something that they weren't supposed to in notifying voters that there was a problem. But the votes, the ballots, a cured ballot is by definition a legal ballot, complies with every applicable requirement cast by a qualified Pennsylvania voter. And we've quoted in our brief the Appeal of Simon case. It says, quote, "The rights of voters are not to be prejudiced by the errors or wrongful acts of the officers of the election." And we don't think that the officers of the election made any mistake or made any error here. Even if you accept that allegation, if you accept that conclusion, the voters did nothing wrong. And it just makes absolutely no sense to say the remedy to any of this is that you would disenfranchise voters. We've heard this idea that what is happening here are illegal votes or fraudulent votes. I think it helps to get a little less abstract and talk concretely about what we're talking about. One of the interveners in our case is a 73-year-old woman named Natalie Price. She lives in Elkins Park. She was committed to participating in this election. She cast a mail-in ballot and was notified that there was a problem and it wouldn't be counted. And what she should do is go to Norristown, which is half an hour away, to correct it. So she did. She made that trip. First, she went to the wrong place. You had to go to 2 different sites. It was pouring rain. But she was determined to make sure that she, a qualified Pennsylvania voter, cast one single valid ballot. To call that fraud, to call that illegal is just insulting. To say that thousands or hundreds of thousands or millions of Pennsylvanians should be disenfranchised because of these alleged minor irregularities or slight different practices in one county or another, that just can't possibly be right. So for all of those reasons, Your Honor, this complaint should be dismissed.
Thank you, sir. Mr. Donovan? Very good, sir. I have some questions. So, Mr. Kearns, I'm going to start with you. Again, you're welcome if you think it's best to defer answering this to either Mr. Giuliani or Mr. Scaringi, but I'm going to ask it to you because you've been involved in this case from its beginning. You're alleging that the 2 individual plaintiffs, Mr. Henry and Mr. Lawrence, were denied the right to vote in violation of the Equal Protection Clause of the 14th Amendment. But at bottom, you're asking this court to invalidate more than 6.8 million votes, which we just heard about from counsel, thereby disenfranchising every single voter in the Commonwealth. Can you tell me how this result can possibly be justified?
Your Honor, we're not asking the 6.8 million votes be canceled. We're asking that the votes that were counted without inspection, which are approximately 680,000 votes, be deemed null and void, as you would with any violation of the absentee ballot requirement. And it always is somewhat unfair to the person who has it canceled, but if there's something wrong with an absentee ballot, that ballot's not counted. And in this particular case, it was a plan that was carried out in two different jurisdictions, not in others, to make certain that uniformly Republicans got no opportunity to observe The conduct was egregious. The conduct was premeditated. The conduct was planned. They have to have gotten those barriers beforehand. They couldn't have just done it on the spur of the moment. And the purpose was to have those ballots examined in secret so that only a Democratic office holder would get to see it in just 2 counties and no place else in the state. I heard the representative of Chester County, I believe it was, or was it Delaware, I'm not sure, say that that didn't happen in their county. If that's the case, we would consider dropping that county from the lawsuit. But the reality is that we're not asking for the entire vote to be canceled. We're asking that the remedy be the remedy that is usually applied when there's a violation of the rules with regard to absentee ballots. And this is an egregious violation, a planned violation. And the remedy is really required and is draconian because their conduct was egregious. Who ever heard of 600,000, 700,000 absentee ballots not being examined? It's never happened in American history. So the scope of the remedy is because of the scope of the injury. We're not asking that the entire election be reversed, but these ballots were not examined. And that is not just a state issue, that's a due process issue. We would contend that one of the fundamental tenets of a fair election in the United States is the ability to inspect, particularly mail-in ballots, which are seen as inherently difficult, fraudulent. You can go to all the authorities. We've been afraid of that for 20 years. Now we have it, and the only way we can police these ballots is only one way. That's the inspection. If you're going to make a mockery of the inspection, I don't know where we're going to go. I mean, as far as we're concerned, Your Honor, those ballots could have been for Mickey Mouse. We have no idea. Have no idea. This has never happened before. And it didn't happen. And the reason I pointed out that it happened in other states, for which I was personally criticized, is because there was a connection here. There's a connection between Philadelphia and Pittsburgh. And then exactly the same thing happened in Detroit, and at the same time, and exactly the same thing in Milwaukee, and exactly the same thing in Nevada. Republicans were uniformly refused the almost obvious right to inspect an absentee ballot. I've never heard of that before, that an absentee ballot wasn't examined, and it was done for a specific purpose. If that ballot were a perfectly fine ballot, Your Honor, why wouldn't they have invited the 18 Republican inspectors that were there, or 20 or 30, that they were keeping in a pen? Hey, take a look at it. It's a real good ballot. And then if you look at where they were and where they came, they started the process at 800,000 votes, 700,000 votes behind. And they caught up in counting a lot of those ballots very furiously. Some of our witnesses will say that they saw them not even look at the envelope, just throw it in a bin, throw it in a bin, throw it in a bin, throw it in a bin. And I also take exception to their saying we didn't plead it and that I didn't plead it. My goodness, Judge, I was accused of not reading your opinion, and if I did, not understanding it. I have read your opinion, and I do understand it, and it's completely distinguishable from this case. You were dealing with pre-election, and you were dealing with what could arguably be considered an injury that may or may not happen, a generalized grievance. We're not dealing with that. The election's over. Those two men just lost their right to vote. They lost their right to vote because they were treated differently in their counties than they would have been treated if they were in Philadelphia or if they were in Pittsburgh, where in fact the secretary varied the law. The law is clear. You can't cure a ballot. It's clear. The legislature hasn't changed that. The secretary has no legislative power, Your Honor. And then they say that those two plaintiffs, our clients, should sue their counties. For what? For following the law and not violating the law like their counties? Why? I mean, if I were in that county, I'd look at the law, and the law says you can't cure a ballot. But then the secretary says, oh, it's okay to cure a ballot. As a good lawyer, I'd say to my client, secretary doesn't mean anything. She can't or he can't vary the law The law is set by the legislature. And this isn't some technical law like, is it 3 days or 4 days? It's can you fix a ballot that is invalid? That's a substantive law. And I would tell my client, don't do it. So I don't know what we would accomplish by suing those two counties. They didn't do anything wrong. The county that did something wrong are the counties that varied the law to make it easier to accumulate enormous numbers of illegal votes. Now they say, well, we don't know how people voted. We do know that in Philadelphia, the vote was 8 out of every 10 for Biden. So let's not be stupid. I mean, that's ridiculous to say we don't know what would happen. And if it was equal over the entire state, why don't they do it all over the state? But the reality is this was a deliberate plan to do this. And to say that we didn't allege these voter violations of the inspectors, Your Honor, from page 56, in every instance where an absentee mail-in ballot is opened and canvassed, poll watchers are supposed to be present. Defendants have not allowed watchers and representatives to be present when the required declarations are containing official, when the ballot envelopes are open and when such ballots are counted and recorded. Isn't that what I said? It's in the complaint. I wasn't making up the complaint, and I feel aggrieved by their misrepresenting what I said. I mean, to say that it's not in the complaint is just plain wrong. In Delaware County, observers were denied access to a backroom counting area. Other Pennsylvania counties provided appropriate reviews. However, in defendants' counties, they were denied the opportunity to have an unobstructed observation and ensure opacity. I'm not quite sure I know what opacity means, but probably means you can see, right? You can see. Well,
I think it means you can't.
It's a big word, Your Honor.
But no, it's for me too. Let me move to my next.
And just one last point, Your Honor. Those allegations, which take up 5 pages, and also allege, as they said, we didn't allege a specific amount of ballots. I don't know, 680,770 sounds pretty specific to me. That's number 142. And finally, all of that is incorporated by reference in the first count, denial of due process.
Thank you.
Well, just to, Your Honor, you asked me to be helpful to the court, and just to circle back to your original question, because I think we got off on a tangent. We do believe our equal protection claim is well established and strong. And it should not only survive the motion to dismiss today, because that's what we're here for today, but also warrant the extraordinary relief of the preliminary injunction. And that's why we're here today. State law can say count certain votes, and it can say discard certain votes. It can say that. But what it cannot do is say under the U.S. Constitution, count some votes, but don't count other votes depending on where you reside in this Commonwealth. And that's what happened here. And that is the simple issue. And I know that today it went off into other issues, but that is this issue why we're here today. We believe that the equal protection violations are absolutely undeniable. And the fundamental question that you have in front of you is how extensive and how pervasive are those undeniable violations. And at this point, if you go through the pleadings, the defendants are flailing and they're grasping at any excuse not to answer those really simple, targeted questions that we asked. We're just asking that the defendants be transparent, and the stakes are high here. The stakes are very high here, and we're asking the defendants to be transparent immediately because there is irreparable harm. So to the extent that you're talking about all of the votes, today what we're talking about is the motion to dismiss and the preliminary injunction to get us through to the hearing on Thursday, when Your Honor can hear what we want to present with our witnesses and then decide those questions.
Your Honor, we're asking you for a hearing. And as far as the remedy is concerned, once we have an opportunity to present the evidence to you, you'll decide whether or not the remedy is too broad, too narrow, the right remedy, the correct remedy, or you'll decide that our witnesses aren't telling the truth. But we no longer have an opportunity to go to the state courts, the Supreme Court of Pennsylvania has now decided that presence only means being in the room and not having an opportunity to observe, which would be in conflict with the law in 49 other states, which I believe does give rise. The man who was very angry at me, I've forgotten his name, he said that it's not a good equal protection claim. Well, it's a darn good due process claim, since it is part of the fundamental rights in an election in 49 other states, and it used to be a fundamental right in this state. So that's a case that really gives us another claim that just arose today. But it can only be brought in a federal court. The state courts are virtually close to us now. We can't make this argument in state court.
All right. Before I get to my second question, Mr. Donovan, you have something you
Yes, I'll brief. Judge, I actually want to answer your question. Page 62 of the First Amended Complaint. Plaintiffs ask this court to enter judgment in their favor and provide the following: an order, declaration, or injunction that prohibits the defendant county boards of elections and defendant Secretary Boockvar from certifying the results of the 2020 general election in Pennsylvania on a Commonwealth-wide basis. That means no certification of president, no certification of attorney general of the state, auditor, local races, in the houses. That's what they asked for, Judge. So when they didn't answer your question, that's really problematic, and I think Mr. Giuliani is going to be more aggrieved because, in fact, he deleted his due process claim. So when he talked about canvas people, he deleted it. And when he talks about 680,000, it has nothing to do with the claim in this case. I know Mr. Giuliani wants to talk about his canvas that now is no longer a claim. It's not in the complaint before the court. And I do this, Judge, because I want to bring it. I've been before, Your Honor. I appreciate it. But I'm bringing it back to this pleading, Judge. This pleading is defective, and they've asked you for extraordinary relief, so I wanted to answer that question. Thank you.
Thank you. Let me ask my next question that sort of flows from the first. And again, I'll direct this to plaintiff's counsel. You can choose who should respond. In the amended complaint, the pleading that I'm looking at, you repeatedly mention the dangers of voter fraud, in particular susceptibility of mail-in ballots to fraud. However, neither count in your complaint seeks relief from any fraud. Am I correct?
Your Honor, the amended complaint, as it was filed, seeks the specific relief that I mentioned earlier, which is the
Noted. So it's correct to say then that you're not alleging fraud in the amended complaint?
No, Your Honor, it is not. Because we incorporate by reference in 150 all of the allegations that precede it, which include a long explanation of a fraudulent process, a planned fraudulent process.
So you are alleging a fraud?
Yes, Your Honor.
All right. Well, if you've acknowledged at the beginning of the hearing that the only issue in the case is the equal protection claim related to ballot curing procedure, but you've repeatedly spoken now about claims relating to alleged violations of your right to have poll watchers present during the ballot counting process. Your poll watching claims were deleted. They're now not before this court. So why should I consider them now on oral argument when you deleted the claims and thus took them out of this action, something I think Mr. Donovan has just referenced? Remember what I'm bound to look at this point. I mean, that's what I'm bound to. The complaint's been amended. We agree?
Oh, certainly, Your Honor. Yeah, it's been amended.
So since you claim that you're alleging fraud in the complaint, putting aside for a moment whether or not I think that's an accurate description of the pleadings, then this complaint has to satisfy the heightened pleading standard imposed by Federal Rule of Civil Procedure 9, is it not? Something that Mr. Donovan is referencing from a prior matter that he had before me some years ago. Sort of a private joke, I suppose.
Mr. Breyer was here too, Judge.
It's not even a very funny joke.
But, Your Honor,
but it's adherence to the rules, I guess, is what he's driving at. Aren't you, Mr. Donovan?
Yes, Your Honor.
But I mean, isn't that it?
Yes, Your Honor, and I really have to correct what I said, because we'd have to interpret it. We'd have to interpret it to charge fraud.
Right. So
what it charges is the conduct in 132, 149 without character.
I understand that. So the amended complaint, does the amended complaint plead fraud with particularity?
No, Your Honor. And it doesn't plead fraud. It pleads the plan or scheme that we lay out in 132 to 149 without characterizing it.
Understood. Now, I want to talk about standing for a minute. I have some questions in standing. I understand that the new theory is based on the claim that the individual plaintiffs were denied the right to vote. You've stated that this is the injury your clients have suffered. In the amended complaint, you allege that the individual plaintiffs tried to vote in Lancaster and Fayette counties, but by your own admission, it was those counties that rejected those individual plaintiffs' votes. So why are you before me in this court suing the defendants for something that Lancaster and Fayette counties did? In other words, why didn't you just sue the counties that actually caused your clients' injuries? We've talked about this a little bit, but that was addressed by the defendants, but I'm not sure specifically by you. You want to take that up?
Sure, Your Honor. The violations or this issue was triggered when we learned after the election that certain votes were counted and certain votes weren't. In terms of certain voters were given the opportunity to cure and certain voters weren't. And those voters lived in different parts of the Commonwealth. And we believe that we have standing in this court, in a federal court, because the alleged violations of equal protection turn not on transforming the state law into a federal question under the Third Circuit case that we've been talking about, but on the unequal treatment of the voters regardless of what the state law says. So we're not asking you about state law, we're asking you about the equal protection claim. And like I said before, state law can say what to count or what not to count, and that's not an issue here. It cannot say that the under the U.S. Constitution that they're going to treat different voters differently, and that's what happened here. If you lived in Philadelphia or another county in the north or the west of the state, your vote was treated differently. And the gentleman from the NAACP talked about a woman who was notified apparently that she had sent in her ballot and there was problems with it, and she was able to get to the voter registration office and fix it. And that was a compelling story. But we have a compelling story in our complaint because our two plaintiffs did not even know there was a problem with their ballots until a couple days after the election. So they did not have the same opportunity as a plaintiff, as a voter in a county where they were being told in some type of a pre-election day review of ballots that there was a problem. So that's what this issue comes back to, the unequal treatment. And that's why we have standing in this court. It's under the federal constitutional claim.
Your Honor, if I may, interestingly, on page 54, the new number is 127. I think the issue that she's describing is really very clearly laid out, because it says in Philadelphia County, they were allowed to cure, particularly a lack of a secrecy envelope. Well, that's exactly why Mr. Henry's vote was declined in, I guess it was Lancaster County. Yes. And whether one is legal or not, as Ms. Kearns points out, I believe it is illegal to cure. I think the law of the state says that. And I don't think the Secretary has a right to vary that. But that's irrelevant to what we're arguing right now. What we're arguing right now is if you set up a system that allows cure, you can't have the system for the northern part of the state, but not for the southern part of the state. You can't have it for Philadelphia County, but not for Lancaster County. That's exactly what Bush v. Gore is talking about. That is about as classic a case of denial of equal protection with a sacred right, the right to vote. It can't be played with that way. And I think that's the point that we're making. I think that's an unassailable equal protection claim for the two plaintiffs, particularly Mr. Henry, who happens to have done exactly in his county, where he was denied the right to vote, what happened in Philadelphia, where they were given the right. And it's the Commonwealth that really denies him the right to vote, not his county.
Well, that's what I'm driving at. So why is Secretary Boockvar here? I mean, you don't allege that she personally rejected the plaintiff's votes or had any authority to do so. So could you explain how the Secretary of the Commonwealth's actions caused Lancaster or Fayette counties to deny the plaintiffs the right to vote? How did Secretary Boockvar's actions affect these individual voters in Lancaster and Fayette counties?
Right, Your Honor, if you review our motion for a temporary injunction, you'll see that the Secretary periodically put out guidance. And the Secretary is not an elected official and does not have the authority to interpret the law or change the law. And periodically she would put out guidance. And not all counties, it appears, might have followed it or had the ability to follow that advice. And the night before the election, apparently an email went out to the counties from the Secretary of State's office. It was not made public. It was not public guidance. And it told the counties, I think it went out at 8:38 p.m. from the Secretary of State's office telling the counties to, during the pre-canvass the next day, and pre-canvass is when that was the first time anyone was supposed to start to look at these ballots. Under the Pennsylvania Election Code at 7 o'clock on Election Day, that was the first time anyone was ever supposed to look at these ballots. So that triggers, well, why was everyone looking at the ballots before Election Day? But then when the Secretary's office put that email out the night before, first of all, it was 8:38 p.m. when it got put out. And some counties apparently followed it, and some counties apparently didn't. And our plaintiffs are a great example because no one told them, no one asked them to come in and cure their ballot or that there was anything the matter with it. And they didn't find out until a couple days after the election. And Your Honor says, well, why didn't they sue their county? Well, you sue their county afterwards to say that their ballot didn't count. So the issue here is that the guidance and
well, yes. Yes.
Have each individual, well, Your Honor, and that's why.
Isn't the remedy ultimately in the Court of Common Pleas of Lancaster County and the Court of Common Pleas of Fayette County, or the appropriate, state judicial districts? I think they're individual. I think those counties make up their own judicial districts, if I'm not mistaken. Well, correctly.
That would be.
Isn't that where you go?
That would be a state law claim. That would be asking the county, telling the county you didn't treat my individual vote correctly. What we're here today, though, is an equal protection clause, an equal protection argument for all citizens of the Commonwealth, that all citizens were not treated equally. So that is different than just simply taking it to a county under a state law claim after the election. What's before Your Honor today is that because of the actions of the Secretary of State and the various county boards of elections, voters were treated differently. And that's what's in this federal court today.
Let me switch gears. And I want to talk now about the Trump campaign's equal protection claim against the defendants, which you've just referenced. Can you clarify whether the campaign is bringing its own equal protection claim or whether the campaign's claim is derivative of the individual plaintiff's injuries? Follow my question?
I think I follow.
It's your statement to me, your argument just a moment ago, sort of is a lead, it seems to me, into that. So is the campaign's claim derivative of the individual, two individual plaintiffs' injuries?
My answer would be, it would be both. That it's derivative of the individual voters, but the campaign is also suffering an injury because and remember, we're here today.
What is the injury?
Of the voters or the campaign?
The campaign.
That the votes, that because of the unequal treatment of the voters across the Commonwealth, certain votes were counted properly and certain votes weren't. Because if we don't, and this is the subject of our term. And that's why we needed that answer, because if everyone would have had a chance to cure, if everyone equally had a chance to cure, if every voter in this Commonwealth had a chance to cure, it was very likely that the result, and this is what we're alleging in our TRO, it's very likely that the results would have been very, very different. And or on the flip side, if no one had a chance to cure, if no county had implemented this procedure, the results would have been very, very different. And that is a injury to the campaign.
You see, Ms. Kearns, aren't you so happy that I kept you in this case and didn't, exclude you because I did your co-counsel from Texas?
Well,
you are.
I think you're happy because I think you wanted my answers.
Well, I'm asking if you're happy. I'm a neutral player here. Here's my next question. Why does the campaign have standing to vindicate the plaintiff's rights when the plaintiffs themselves, the individual plaintiffs, appear to be capable and willing to vindicate those rights on their own?
Well, they can, and we're.
But why does the campaign have standing? Why does the campaign have standing when the individual plaintiffs have the ability, the willingness, the capability to vindicate those rights on their own, the two individual players here?
Yeah. Your Honor, the campaign's right to raise denial of equal protection derives from the plaintiffs in one sense, and then it's the campaign itself that was denied equal protection. So the net result of these two plaintiffs not being able to cure their ballot is that the campaign was harmed because in one part of the state, they would have been allowed to vote. In another part of the state, they're not allowed to vote. And it just happens, if you analyze the two parts of the state, that the part of the state where they're allowed to vote and allowed to cure, even in violation of state law, is heavily Democratic part of the state. That was 80%, 70% to the other side. And then we look at all those other counties, and they weren't allowed to, and they didn't. And why is the secretary involved? Because this happens because of the inconsistent advice being given by the secretary, in which she puts these election...
Was it inconsistent advice that you're no. Selective advice?
Selective advice, and also very ambiguous advice. So if you were sitting in one of those counties that is one of those Republican counties, and you get the memo from her, and you talk to your lawyer is going to have a real problem, because your lawyer is going to say, I'm sorry, but nobody changed the statute to allow curing, and you're allowing it.
Of course, the thing of it is, I mean, we get into the nuances of this. I used to be involved in this sort of thing a long time ago. I mean, I look at it, Fayette County. Fayette County is a traditionally Democratic county in the state. Lancaster County, traditionally a Republican. Now, the things are changing out there, but I don't know.
Quite a bit.
But I would suppose that the Fayette County's registration is still heavily Democratic, isn't it? Even if they don't vote that way.
But
in a presidential race?
Yeah, but I'm not sure that...
Well, that's the point. It's Democratic county.
But I'm not sure in this particular election that's as important if it's a very, very strong Trump county.
All right.
I mean, that's where...
But the Democratic-Republican end of it is...
Well, then maybe we should say Trump-Biden.
Well, yeah, well, in a way, that's sort of smeared together, because you're going to have some traditionally Democratic counties, particularly, I think, in the western part of the state. The exceptions to that. Butler County, traditionally very Republican county. Allegheny County, heavily Democratic county. But a lot of the neighboring counties are traditionally, in my historical sense, in modern history of the state, traditionally Democratic counties, and yet many of those counties are counties that voted for your man, I think, in this last election, and did so 4 years ago in 2019. But they'd still be Democratic counties.
But as again, I don't know if that's relevant in the modern world that we live in. And the reality is, this confusion is created because of whatever we want to call it, inconsistent, ambiguous advice being given by the secretary, who doesn't clarify to anyone, how is it that I can change the cure provisions of the legislature? So people, and running an election like that is in itself also a violation of due process, which is why I want to restore the due process.
I want to have another question on standing here for you. In the briefing, the plaintiffs assert that the campaign has competitive standing. None of the cases you've cited for this proposition are from the Third Circuit, however. So is there any precedent that plaintiffs' counsel can cite from this circuit expressly addressing the theory of competitive standing?
Well, Mr. Marks.
Mr. Marks is going to help you. That's fine.
He leaned over and said, Marks v. Stinson, and we have the unusual situation of he was the plaintiff in Marks v. Stinson.
Your Honor, if I might, I don't want to do anything inappropriate, but you asked for a cite, and I would.
Yeah.
If Your Honor looks to the Marks v. Stinson case, there's a reported final injunction decision. In
what court?
Eastern District of Pennsylvania, Your Honor.
Which judge heard it?
Judge Newcomer from Lancaster County, was Republican then.
Oh, I remember him.
And Your Honor, it was affirmed.
What year was that?
Your Honor, the election was 1993. The case was tried in a preliminary injunction in February of 94. The critical Third Circuit opinion affirmed the preliminary injunction in part, reversed it in part, removing my opponent and saying that the judge had to go back and have more hearing to determine if I won. And then there was a final injunction decision that was entered in April of 1994, which was then affirmed by the Third Circuit, where Judge Newcomer concluded if you set aside your illegal ballots, the absentee ballots which resulted from a massive fraud, that I was the winner and that my opponent was the loser. In that case, Your Honor, the Judge Newcomer held under the Equal Protection Clause that the election board in Philadelphia, the same board that's being sued today by the Trump campaign, that they couldn't favor one candidate over the other. You couldn't give a competitive advantage to the Democratic candidate. I was a plaintiff. You couldn't give a competitive advantage, let alone in violation of the state law, to one campaign over the other.
And this addressed competitive standing?
Yes, it was competitive. It was standing. They held that I, as the candidate, I wasn't incorporated. I'm not like Donald Trump.
No, I understood.
But, that I, as the candidate, had standing because the state actors, it was a civil rights claim just like here, it was also an equal protection claim, that I had standing because the government couldn't put its thumb on the scale in favor of one candidate over the other. And that's what happened in my case, because they were violating the law and giving absentee ballots themselves to campaign workers who were, you know.
No, understood. All right, that's good. What's the case again?
Marks v. Stinson.
Marks v. Stinson.
I actually gave it to the mayor.
All right, we'll look it up.
So, Your Honor, it's sort of this, if I just might, then I'm going to step out of this. It's sort of the same thing in this case because there were no observers. The people who ran the elections in the 7 defendant counties knew that the mail ballots were going to be heavily in favor of candidate Biden. They knew that from the registrations of the voters who had submitted them, and they also knew it from the publicized campaign strategies. They knew that the Trump voters were going to go to the polls. They knew that the Biden voters were going to vote by mail, so that they didn't allow inspection, and if they allowed ballots that shouldn't have been counted because they didn't have a signature or they didn't have the date on them. Technical things, but that is our, Your Honor knows that's our requirements in Pennsylvania. No different than if you vote at the polls, you've got to be there before 8:01 or it doesn't count. So that was the competitive standing determination in Marks v. Stinson, Your Honor, and I'd suggest that analogy would apply here.
All right, that's good. We'll look that up. Thank you, sir. Now, beyond competitive standing itself, is the campaign raising any other theories of standing? Beyond competitive standing, any other theories of standing you want to address with me?
Yes, Your Honor. We have standing as having been aggrieved under the Equal Protection Clause of the United States Constitution. We were treated in all of the different respects in which we outline in this complaint, not just curing ballots. We were treated differently than the candidate on the other side. We were cure provisions, backdating provisions. You look at the individual allegations against the different counties. Each of those treats our side, I'll call it the Trump side now, and the Biden side rather than Republican and Democrat, differently than the Democrat side. And the allegations about the inspectors, the watchers, is incorporated by reference in the equal protection claim. And there, not alleging fraud, we're alleging denial of equal protection. In certain counties in the state, there was no inspection. In other counties in the state, there was very rigid inspection. And in fact, in most counties in the state, there was rigid inspection. The difference between the two, if you take a look at it, in the Biden counties, the 70%, 80% Biden counties, there was no inspection. And in the Trump counties, there was the usual rigid inspection. So if you look at the 680,770 ballots that went in Philadelphia and in Pittsburgh, that were never inspected, he used just statistical probability, expert testimony, which is allowable in an election case, it would be 8-2. If you go look at the counties that had rigid inspection, the percentage is going to be more like 60-40, maybe 70-30 Trump. When you have rigid inspection, more ballots are going to be rejected. So that's another way in which we were treated in a disparate fashion and not subjected to the same standard. I mean, the reality is, on issues like this, counting votes, curing votes, one of the gentlemen, I think quite rightly said, you're not going to have rigid similarity in every single county. Different times, different rules. But we're not talking about little technical rules here. We're talking about whether an absentee ballot is accepted or it isn't accepted. We're talking about whether if you mess up a ballot, and the rule has always been once you messed up one of these ballots, you're finished. You can't fix it. Pretty much the case around the country. Now all of a sudden a new concept is floated by the secretary that you can cure it. But nobody bothered to go to the legislature and have the legislature change the legislation. So it set up a situation of mass confusion. Well, that alone deprives you of equal protection and due process. An election like this shouldn't be conducted with mass confusion over whether you can cure a ballot or not cure a ballot, or whether you should have inspectors or you shouldn't have inspectors.
We're watching Mr. Donovan. He's been itching to stand up here as he's moving around in his chair at council table. Do you have something to add on that point, Mr. Donovan?
I do on the prior one too, Judge. Marks v. Stinson, I just did a search.
Right.
Competitive doesn't even in the opinion, so it's hard to understand how it's competitive standing is in the opinion since the word doesn't appear. The only time...
Well, we didn't find it. That's why I'm interested. We'll read the opinion.
No, sure.
I had maybe difficulty finding it.
I just wanted to put a little finer point since that word doesn't appear. It's hard to see that it stands for that. In fact, all of...
We understand when I'm talking about competitive standing. It has meaning, specific meaning, not dismissing what Mr. Marks told me. I didn't find that in my research because it's specific as to that language. All right, go ahead.
One more point. There's a little freelancing going on over here about advice from the secretary. The secretary issues advice or guidance. She issues it. When she issues it, it goes on a website. Everyone gets, and it goes to all counties. If you review the guidance, Judge, or Mr. Giuliani, you'll see that these instructions do not go to specific counties. She gives guidance, which is her role. As the secretary taught me and reminded me that Pennsylvania is a commonwealth. She cannot enforce, but she gives guidance as her role is, and she gives it to all counties at the same time, and it's on the website, and it's still on the website today.
All right, good. I want to turn to the merits now. What standard of review should I apply and why? What standard of review should I apply in this case?
On a motion to dismiss? Well, I mean, I think the normal one, which is that you have to deem the factual allegations to be correct, and even if they are correct, you'd have to find that there's no merit, no legal theory on which we can get relief.
Well, let me ask you, are you arguing then that strict scrutiny should apply here?
No, the normal scrutiny should apply. If we had alleged fraud, yes, but this is not a fraud case.
So if that's so, what's this background noise? What is it? Oh, Aaron, check. Are you moving around again?
I just want you to remember I'm here. I want to say a couple things at some point.
Oh, we'll get back to you. We haven't forgotten about you. Try not to move around. So if that's the case, why don't Secretary Boockvar's and the counties satisfy the standard review that you're talking about? If it's not strict scrutiny and it's the standard review you're implying, why don't their actions satisfy this?
I'm sorry, I don't really understand the question, Your Honor.
Well, this is how I would look at it. I would think that it's a standard review of strict scrutiny potential. You're not sure that that's the case. I'm not imposing my.
Maybe I don't understand what you mean by strict.
Well, for strict scrutiny to apply, a fundamental right needs to be burdened, as I understand it. So how do the counties or Secretary Boockvar, on behalf of the Commonwealth, burden the plaintiff's right to vote? How do they burden the right to vote?
Based on issuing these opinions that are confusing, ambiguous, in several instances contrary to the law, it's very, very hard to have consistency in the principle. Let's stick to the one we've talked about most often, about whether you can cure a ballot, whether you can supply the information after the fact. She created a great deal of confusion about that and never clarified it, so that she conducted, I guess the language in Bush v. Gore would be, an election without standards, without uniform standards.
Well, I follow that, but how does making it easier for some people to vote burden the plaintiff's ability or right to vote?
Well, it isn't so much making it easier to someone to vote, it's specifically the same thing. It's exactly the same thing, at least in the case of Mr. Henry. Mr. Henry made a mistake.
So his right to vote was burdened by the Secretary's actions?
His right to vote was denied by the way in which the Secretary's advice was interpreted in part of the state, and in his part of the state, it was interpreted differently. Pennsylvania conducted an election in which people in different parts of the state had a right to vote under certain circumstances, and other people didn't. So in Pennsylvania, as we allege in the complaint, when someone had a ballot in which he didn't use the secure envelope, that person in Pennsylvania, in Philadelphia, was allowed to vote. In the case of...
How are Mr. Roberts and Mr. Henry are the individual plaintiffs? So how are they actually denied the right to vote? If I understand it, they filled out their ballots incorrectly, and then their individual counties, Lancaster County and Fayette County, didn't count them. But you're not saying that every ballot that isn't counted, for whatever reason, constitutes a denial of the right to vote.
No, but here, Your Honor, and there was a perfect example from the gentleman from the NAACP. Here, Mr. Henry and Mr. Roberts voted, and their vote ultimately was, they did not have the ability to cure that vote. The government, the state actor here, did not give them the ability to cure that vote, whereas other voters were given that opportunity. They were, and you'll hear this.
But is that a denial of the right to vote?
Yeah, we would absolutely.
The actions of Lancaster and Fayette counties, is that a denial of the right to vote?
Yes, because every county should have had the same procedure.
Either they should have been allowed to cure, or nobody should have been allowed to cure.
But, Your Honor, but the issue here is that the procedures were not all the same. So, from Mr. Henry's perspective and Mr. Roberts' perspective, their ability to vote was denied, because had they simply lived in a different county, their vote, they would have had the opportunity to cure, and therefore that vote would have been counted. And these two gentlemen their vote was not counted, so they did not vote. Their vote was denied.
All right, let me move away from strict scrutiny and go instead in another direction, and that is, if I conclude that rational basis review is appropriate, why don't the defendant's actions satisfy this standard? We have a strict scrutiny standard, we've got a rational basis standard. It's a different standard. So why don't the defendant's actions here satisfy that standard?
Well, how is it rational to have in one state two vastly different standards about how you're going to deal with what turns out to be 2.6 million votes? And depending on the location in the state, which is exactly what Bush v. Gore uses as an example of a violation of equal protection. I mean, how can that be possibly rational? Whatever you say about her advice and the advice of others, the result of it was a totally unequal, completely unfair election, in which in one part of the state, if you did what Linda just said, if you made a mistake, you don't get counted. In the other part of the state, if you do make exactly that same mistake, your vote is counted. And forget even now Trump or Biden. In Bush v. Gore, they say you can't have different standards based on location. You can't say that somebody has a right to vote under certain circumstances in one place, but then under the same circumstances in another place, they don't have a right to vote. Or in this particular case, the right to cure an absentee ballot.
But in order, I don't think there's
anything rational about that.
Let me cut to the chase here. In order to violate the Equal Protection Clause, the defendants needed to have done more than simply violate state election law. So why is this constitutional question and not simply a matter more appropriately determined, as I suggested before, in state trial court and with appellate review?
But it really isn't a question of whether it so happens they violated state law. But that isn't we're not charging them with violating state law. It could have been some other way in which they did it. What they did was they set up a system where you have two different, fundamentally different sets of rights in one part of the state as opposed to another. Again, in one part of the state, if you make a mistake, it gets fixed. In the other part of the state, you make a mistake, you don't get to vote. It doesn't even matter if it's Biden or Trump, Republican or Democrat. The fact that you have two disparate standards in different parts of the state means that they have set up a standardless election, an election in which the standards are not uniform about something very, very important. How are you going to deal with an absentee ballot, particularly in an era in which that's going to become a much more significant part of the vote? If anything, the uniformity of those standards, the scrutiny applied to it, should have been greater, since it now became a much more meaningful part of how you're going to decide the election.
In fact, I have some questions for the defendants. I'm going to look to you, Mr. You want to ask?
Can I respond to these, or am I going to get the same ones? I just want to
No, you're getting different questions.
I'll be short.
Let's go ahead.
First, on your first question of strict scrutiny, there is no strict scrutiny because I think as the colloquy showed, these two individuals were not denied their right to vote. They vote, it was defective, and what the secretary and what some counties may have done is what you said, Your Honor, which is they try to make it easier to vote. That, in my mind, is the opposite of a burden.
So the standard review instead is the
rational basis, Judge, and then what happens is, since there is no vote denial in this case, there just isn't, it's dilution, rational basis, BOGNET forecloses it. So that's one. Second, Mr. Giuliani keeps referring to standards. And in fact, there's election law, and the secretary issues uniform standards. What Bush v. Gore talked about in standards is the Florida Supreme Court actually told different counties when they were in the middle of recounts to stop at different points. So the standard there was they weren't counting all the votes. What I showed you this afternoon in my PowerPoint presentation, Judge, was all the cases that say you can have some differences among counties without being able to establish an equal protection clause. Thank you.
Well, let me. I'm going to start with you, Mr. Donovan.
Okay.
I'm looking to you. Mr. Aronczyk, I think, wants to speak, and I'm going to let him do that, and he is welcome to answer some of these questions as well as are any of the other attorneys present. Care to defer to them. So first question is this. Mr. Giuliani has noted that the Bognet decision's interpretation of standing was based on a future inquiry. Why is that case not distinguishable here, where the alleged injury happened in the past? Understand my question?
I do. If I may, Judge, it is for the same reasons Judge Ranjan, that they're together. The reason why is because it isn't the temporal aspect that is the problem there. The issue goes back to, is it vote dilution? And is it a specific particularized harm? That was the point about drop boxes in Judge Ranjan or in Bognet. It's not the timing, Judge. The question is there a general harm that's done to all voters? And when it is, an individual doesn't have standing to assert an equal protection clause. They might have state law remedies, but that's what those cases stand for, Judge.
Good. Thank you. Next question is, why doesn't the Trump campaign have standing here?
For a couple reasons.
Just sum it up for me again.
Yeah, sure. So first, Judge, there's no such thing as derivative voting or derivative. I think they called it derivative. That doesn't exist, number one. They have to have their own standing. And the problem is they don't have any competitive standing because they, at least as alleged, and that's what we're dealing with, is the First Amended Complaint. And they also have no standing because, again, I go back to Bognet, is they can't actually point to anything that has causation or redressability or the different reasons in your voter alliance. I won't go through those different doctrines, but that's why, Judge.
Your Honor, if I could respond.
Yeah, go ahead.
Those. Well, first of all, on dilution or denial of the right to vote, the fact is the vote wasn't counted, Your Honor. I mean, I can't see what the difference is if I'm not allowed to go into the voting booth and kept out, or I go in the voting booth and they cancel my vote. I mean, the fact is, the vote wasn't counted. That's a denial of the right to vote, particularly if I lived in another location in the state, I would have been allowed to vote. That vote would have been counted. You can't have, in a presidential election, a nationwide election, you can't have two different standards, two different practices, let's say, in different parts of the state. I do precisely the same thing in one part of the state, and you count my vote. And I do the same thing in another part of the state, and you don't count my vote. And it's almost a distinction without a difference to say, oh, that's dilution rather than denial. The vote didn't get counted. Therefore, the vote was denied.
Thank you. Mr. Donovan, next question. Why isn't this injury, either by the campaign or the individual plaintiffs, redressable?
It's not redressable, Judge, because it comes back to the cases we walked through. That is, the alleged harm that is here, I think as alleged, is that some individuals were able to go vote provisional, which, by the way, is a standard. It's part of the election code, and any voter can go do it. It's actually required by federal law as well. But when that happens, Judge, the harm there is the dilution to everyone. So what Judge Ranjan, I know your opinion, so assume someone goes and they vote, and it is wrong. They shouldn't have voted, okay? And what those cases stand for is that is a general harm to the entire statewide tally, not to Mr. Henry, not to Mr. Rogers, not to any campaign. Because, as Bognet said, then when you look at a campaign are the rules that are out there affecting all candidates, auditor, treasurer, president, and that's what it holds.
Thank you. Can you explain to me why the Pullman abstention applies in this case?
Yes, Judge.
Or should I ask Mr.
I mean, Mr. Aronczyk can, if he wants to take.
Mr. Aronczyk, you want to take that one up? It's really your wheel.
I'll take that one up.
Yeah. Why does Pullman abstention apply in this case?
For the same reason that Judge Ranjan analyzed, in that we have a comprehensive election code with remedies, and Younger is interfering with a remedy, or at least allowing a remedy that's chosen to go forward. Pullman is, if you have comprehensive remedies that are available to you, and particularly in the context of the presidential election structure that Congress has set up, you need to go to those remedies, and it's classic Pullman. You can go, and what's happening here in this case is there are ongoing proceedings that they could intervene or at least even raise the issues. Ms. Kearns has already told you that. And there are proceedings that are available to them, i.e. Pullman, that they can then invoke to try to test these issues. But, Your Honor, I don't want to get off your question, but I wanted to, well, only if it's appropriate, make one other point.
Well, let me got you there on abstention. I have another question,
yeah.
Mr. Ehrencheck. You've stated that the Rooker-Feldman doctrine applies because the Trump campaign has already litigated questions regarding public identification of voters who submitted defective mail-in ballots in, if I understand it, Bucks, Philadelphia, and Northampton counties. Did those decisions deal with the notice and cure question at issue here?
No. Those particular decisions dealt more generally with ballots that were either counted or not counted based on defects, the variety of defects that could occur. The Ham case is the one that deals with the notice and cure issues, but it was in front of Judge Brobson. And the Rooker-Feldman doctrine, I don't think applies yet to even that case because it's pending. Rooker-Feldman would apply, for example, to Mr. Giuliani's imploring you to cast aside the Supreme Court of Pennsylvania's final opinion today about observers. That's a classic Rooker-Feldman problem, and so I wanted to differentiate that. Okay.
Well, that's fine. Mr. Ehrencheck, I think you wanted to add something else now while I got you here. Why don't you go ahead and do that?
Yes. The primary, this whole notion of notice and cure is being used very loosely. To focus in on what they actually alleged in the complaint about Philadelphia is, in the paragraph I referred to you earlier, is primarily the issue of people who spoiled their ballot on election day and voted provisionally. And they say these folks had the ability to do that because the secretary issued guidance the day before, and Philadelphia let voters know that their vote is not on the register of approved voters, and if you want to invoke your rights, you can do that. And Mr. Giuliani is, and by the way, it's nothing personal with Mr. Giuliani at all. I'm sorry if he took it that way. It's personal, absolutely not. It's professional about being dismissive of his arguments. But the point he made, he said several times, and I don't expect that he would know the Pennsylvania election code, that the idea of voting provisionally, spoiling your ballot and voting provisionally, is somehow illegal, that the secretary made up law. But it's in the code. The sections I cited to you earlier, it's in the law that you can spoil and vote provisionally. What is important about the standing analysis, in addition to what Mr. Donovan said, is the traceability issue. Because, number one, it's legal to spoil your ballot and vote provisionally. Number two, it's impossible for them to say that Philadelphia's notice advising voters that they can do so. First, as I said before, what's wrong with that? I mean, what world are we living in here? But it's impossible to say that's the reason why any voter went to the polls and spoiled their ballot and voted provisionally. Their own complaint says, in fact, this was a gigantic public issue in the public. And so, I really think it's important to address that point as a matter of standing. And the final, point I just want to make, I'm not going to repeat what Mr. McQuanta and Mr. Donovan and I already went over about equal protection. But the idea that this is a Mark Stinson case is crazy. That Mark Stinson stands alone in the Third Circuit. The Bognet decision pretty much said so. There's nothing about this complaint that meets the Mark Stinson facts. And Mark Stinson said nothing about competitive standing. I mean, that's a completely invented notion. I appreciate that my old and good friend Bruce Marks was in court today. It's nice to see him again after all these years. But it had nothing to do with competitive standing. Nothing. Absolutely. I mean, it's not in the opinion. And what is before you is the Third Circuit law gathered together by Bognet, and it is other circuits that say that in the administration of the vote, even if counties are wrong about how they administered it, those kinds of issues are not equal protection. They're just simply not. And I thank you for letting me deviate from your question on that one.
Thank you, sir.
Thank you.
All right, well, those are my questions. So let's talk about some post-hearing items to address and some other, what I described at the beginning of the argument today as ministerial matters. First, I think the plaintiff should be given the opportunity to file an opposition brief to the motions to dismiss. That hasn't happened. I'm suggesting by 5 p.m. tomorrow, Wednesday, November 18th. And you're agreeing with me.
Your Honor, again, say that again, I'm sorry.
Well, I mean, we should get, I think, an opposition brief from you. I'm willing to take one.
Pardon me? Do we have leave to amend now, Your Honor?
No, we want to, this is a brief in opposition to their motions to dismiss.
Oh.
The motion, I want to give you the chance to brief that if you want to do that.
Oh, sure, absolutely.
Yeah. So I'm suggesting by 5 p.m. tomorrow.
A brief in opposition to basically what they argued today.
The defense, well, the defense filed new motions to dismiss to the amended complaint that was filed on Sunday. But I understand your arguments are, but I'm willing to take it
I understand what you mean.
in written form as well. So in light of our timeline, I'd suggest, doesn't give you quite 24 hours, but by 5 p.m. tomorrow, and then the defendants until noon Thursday, which is November 19, to file a reply brief. I'll issue an order on that, maybe not this evening, but tomorrow morning to confirm it. So brief in opposition to the new motion to dismiss. The first motion to dismiss, of course, mooted out under rules with the amended complaint. So don't bother with that. And then the reply, as I said, by noon on Thursday, November 19. And, I'm sure we'll make that happen somehow or the other. Now, I also suggest that you consider, plaintiffs really consider, whether there should be a new motion for preliminary injunction. There was an initial motion with the initial complaint, but again, there's now an amended complaint, and technically you probably ought to file a new motion for preliminary injunction. Can you do that? And I'm suggesting that you be given until 5 p.m. tomorrow to do that as well, which I think under our time frame is doable. Right? You can redo that from what was done previously. I think modify that margin, make sure it fits. So both of those things by tomorrow at 5, and then I'll give the defendants until 5 p.m. Thursday, the 19th, to respond to that. In doing all of this, I'm looking at Mr. Donovan, but I'm really looking at all of you. So, and then the plaintiffs, I'll give you until Friday, whatever Friday is, the 20th, November 20, to reply.
Will this all be in your order? Because I'm not.
Yes. Oh, you should write it down anyway, Ms. Kearns. That's what lawyers do. They write things down. So that's we'll sketch that out. So there'll be an order tomorrow morning, maybe later tonight. I think my staff probably wants to depart for the evening, but at some point I'll dictate an order, probably docketed in the morning. Right? But you wrote it down. That's our time frame. That's what I need, I think, in terms of papers. Now let me talk about these ministerial matters. First, I don't think it's been filed, but there's a desire, I think, to file a second amended complaint, which Mr. Giuliani.
Yes, Your Honor, we'd ask for leave to do that, to clear up the issues today and also to add
All right, you need to file, have you filed, Mr. Stringy, I'm going to look at it back. Did you file a motion to file a second amended complaint? Filed a motion to continue. I said no on that. But you referenced that, I think.
No, we didn't, Your Honor.
All right. Right.
We did express our intent
You'd like to file, all right. But you need at this point to file a motion, the court's approval, and you might get agreement, or you might get opposition from the defendant. Now, I'm typically not a betting man, occasionally at the track. I would guess that there'll be non-concurrence, but I don't know.
Well, we can open up the floor right now.
Well, we're going to talk about it at the end, because I might resolve all this for you. I'll take you to dinner.
You're a good bettor, Judge.
Right?
I mean, in all seriousness.
A lot of these matters can be cured with a drink and dinner.
Yeah,
I've sent counsel out to do just that. I'm not sure this is one of those cases, but hope springs eternal.
It does. Judge, that's just, I think a couple reasons, Judge. Look, I appreciate the schedule. We obviously don't have the hearing on Thursday. Hope does spring eternal. I think you're going to dismiss this case. I think the law requires it. We'll do the other briefing. But once you dismiss that case, I think then when they file this motion, if you permit them, this is now their third time, okay, an expedited election briefing.
I don't know whether they're going to permit it. I just want to say,
yeah,
they would need to file the motion.
I agree.
To do so with concurrence or non-concurrence of the defendants. I suspect non-concurrence will be coming into play here.
But I guess with that, Judge, I don't want that to moot out. We have spent a lot of time, effort. We have a state election to certify.
Right.
Really want your ruling, and I know sometimes I guess they're going to file a motion for leave, and then we'll
right. Well, that's what I'm talking about. But I don't want to them to think that I've prejudged. I've decided today. I don't want the
understood. Understood, Judge. Understood.
So if you want to send in the next day or so a motion to file, I guess, a second amended complaint, I'll take that up and adjudicate.
Your Honor, may I just clarify just a little bit? We can file with you a motion for leave by tomorrow morning. We can also give you the amended complaint and give them the amended complaint.
Well, you got to go through the.
I'm told we need until 5 o'clock, but
you've got to go through the procedures. You got to get back to them, and we've got to.
But the benefit of that would be that the amended complaint does not differ very, very much from what we've already addressed, with one exception, and that's the due process count.
Well, you're going to attach it. I mean, I'll take it.
Okay.
Mr. Donovan and company will decide how they want to.
Yeah, Judge, I think at this point, we'd also ask that we don't even have to respond to that, Judge, until we get your ruling on the current motion to dismiss.
That may be, but
I understand what you're telling them. I'm just asking for the.
I don't want the plaintiffs or the defendants, but particularly the plaintiffs in this instance, since they're seeking this relief, to think that I've decided the matter. I've got to.
Understood.
I've got to mull it over, frankly. Yep.
Clarification on the motion to leave and file a complaint. The due date would be tomorrow at 5 p.m.
If that works, I think Mr. Giuliani just suggested that's fine with me. I think you need some time to do it.
Yes, Your Honor.
And Judge,
it's not a lot of time, but I don't want to say noon tomorrow when you need to go home and sleep on it and think about what you want to word it. And tomorrow at 5 is fine.
And Judge, we would request to not have to respond even to that motion until we complete this briefing and get your ruling.
I don't have an objection to that.
Thank you, Judge.
All right, the discovery and the questions issue, I'll take that under advisement. Last issue is this, I call it the Kearns versus Kirkland and Ellis matter. That's what I know. All right, so that's, Ms. Kearns, I listened to the, I guess it was a voicemail. Is that what it was? It's somebody, I don't know whether you sent it along or Mr. Donovan sent it along. It doesn't matter. I listened to it. So, all right, so that's bad form. It's not a sanctionable matter. So, Mr. Donovan, I realize it's not you. I realize it's not Kirkland and Ellis, attending this. But where is this? Is this man like in your Abu Dhabi satellite office? You're a big shop. Where was it?
Not yet.
Paris?
No,
Does
Judge.
he still work at the firm?
He does, yes.
Okay. Well, look, you got to go back and tell this guy. I mean, the one thing is, and you've already told him this. I'm sure whoever the managing partner is.
I'm very stern.
Maybe that's you. Look, this is evident. We at least the attorneys would appreciate this. So Ms. Kearns and Mr. Giuliani and Mr. Stringy and the other attorneys who are involved, they have every right to represent the Trump campaign or really anybody they want. They can take up what in some quarters, I suppose, in the professional corridors of Washington, D.C., might be an unpopular cause. Well, you look a couple of rows back at the leader of the NAACP here in Pennsylvania, and you can chat with him on the way out, or better yet, have your associate or whoever he was at Kirkland have a chat with him or his counterpart in Washington. You want to deal with somebody who picks up what might in some quarters be an unpopular cause. Now, I would suggest that representing the Trump campaign in many quarters is not an unpopular cause. I think there are a lot of people, about half, maybe a little less than half the country, by voting population, if we assume that the stats are what they are, I think this is exactly the right thing to do. But what's unpopular to somebody is not popular to another. So he didn't advance the ball forward much with anybody. What you can tell him he did is he took the time of a very busy federal district court judge in Pennsylvania to read the papers, which of course I read because I read everything, listen to this unfortunate voicemail. It just wasted my time. It's not sanctionable, but it's bad form. And you should have a chat. Somebody should have a chat with him about it. You probably already have. And don't do that. Don't do that again. Counsel, I don't know what's going on in this country. These individuals have a right to legal representation of their choice. And it wasn't a threatening call to Ms. Kearns, but it was just, it was, she's probably, using the term broadly, accurately described it as a harassing call. So you can convey my disdain back to your man. He's not going to be sanctioned. I'm sure that your people at Kirkland will attend to that if you haven't already. And Ms. Kearns, I'm very sorry that happened. I understand from my staff that you've gotten other calls of that sort and things, but it's not. Believe me, I've had to sanction a few attorneys. I don't enjoy it. This is not, in my mind, a sanctionable issue. Remember, I'm here for the main event. That's what we dealt with today. These other issues are just, you know what it is? It's piffle. And I'm just so busy that I've got to deal with the main event. And spending any more of my time dealing with that, I'm sorry that you were affronted by that. At least if this young man at Kirkland and Ellis is not sorry about it, I'm sorry on his behalf. But that's all.
May I just briefly be heard on it, Your Honor?
Well, do I need any more than what I've already said?
Well, I want the record to be clear that I did not release that voicemail to anyone except this court, my legal team, and the other side. To the extent that it gets out, it's not from me. And
is it out?
Not that I know of, but I want to make that clear on the record. And when that because Your Honor, I would not want to rain down on him what has rained down on me. And when that call came through, it was more than an inconvenience because I am getting hundreds of calls, and I'm in danger of missing legitimate communications from PACER and from opposing counsel. And when the caller ID said Kirkland and Ellis, I rightly thought it might be from one of the many, many lawyers on the other side. And it took a lot of time for an attorney who's representing somebody in federal court to go through that. And I think what offended me most was that I knew within minutes that it came from Kirkland and Ellis using a Google search to do a reverse lookup. Yet when I reached out to Mr. Donovan on Sunday night, he said he had to investigate. I mean, I already knew. He said he had to investigate, and it was Sunday night and he would get back to me. And he disagreed with my conclusion that it was Kirkland and Ellis. And then when I sent him the voicemail that had the caller ID with it, he simply called it discourteous. And he said the lawyer was not on the file or was not a litigator. And I just felt that that was not a sincere apology, and the smugness and the dismissiveness with which he treated me should not be allowed. And I've represented now the President of the United States, and I've also represented people on small claims court over $100 claims, and I've represented the gamut. And this should not happen to any litigant because my time was taken away from this case because of something that happened in Kirkland and Ellis, and I just feel that should not be allowed. And I defer to Your Honor about sanctions, and I completely understand your ruling, but I want people to understand how this impacted this case, and that should never be allowed. I don't understand what goes on at Kirkland and Ellis. I'm not privy to how they train people, but this should absolutely unvitally not happen. And as we're sitting here today, Mr. Donovan has not apologized to me, Kirkland and Ellis has not apologized to me, and the gentleman whose name I refuse to give out because I don't want this to rain down on him, he has not made a sincere apology. And to me, that's a disgrace.
Right. Well, so noted. Now, is there anything else for today? I'll take the matter under.
Your Honor, I have a question. Your Honor, Mark Aronchik, housekeeping question, housekeeping. I believe that all of us that argue to, first of all, I want to thank you for, for this lengthy day, but and the opportunities. Well, I believe all the lawyers who argued, no doubt, are going to be asked by the press to comment, to talk about this hearing. I have no problem with that one way or another. I suspect that there are certain people in your courtroom who will be asked to comment more than others, and that's okay. I just want to know if Your Honor has a problem in light of this conversation. It occurs to me, I wanted to ask you if you have a problem of lawyers, while this is under advisement, commenting or talking about what happened today, if that matters to you.
No.
Okay. I just wanted to be careful. Okay.
Judge, just to clarify, I think you've already answered it, but there's no hearing on Thursday now.
I don't think there's a need. I just don't think there's a need for a hearing at this junction.
Thank you, Judge.
And so that I will note that as well in tomorrow's order that outlines our remaining briefing schedule. Notes that, and I'll take this matter under advisement and attend to it accordingly. Is there anything else? Yes.
Did you say that you are going to be resolving?
At some point, I'll take care of it. I'll take that up.
And also the motion to quash.
I loop that all together as an ongoing discovery issue.
And also, the plaintiffs would like to file a
send it in tomorrow by 5. If you can do that.
I think we can.
Your Honor, just on withdraw is still pending, so.
You still want to withdraw? Well, look,
Your Honor,
do this. Are you going to? You're staying over tonight? You get back in the morning. You don't know.
No, I'm going to Philadelphia tonight.
Why don't you call my staff tomorrow? Call Mrs. Reinhardt, who's my and just tell me by midday. Think it over.
Okay, I'll discuss it.
I wanted you involved, Ms. Kearns, because you've only been involved from the beginning, and until I had sorted things around with Mr. Giuliani, Mr. Scaringi, allow them to get up and settle into the case, thought it was important that you stay involved. The tax attorneys were fine, but they hadn't been involved in the case a day, apparently discharged or whatever. You weren't. So why don't you think about what you want to do?
I have to discuss with the client.
Yes, well, indeed, and you decide yourself what you need to do. But if you want to do that, why don't you just send in a very short one-page motion singularly for you? And if that's what your desire is, then let Ms. Reinhardt know you're going to do that. I'll take you off immediately.
Thank you.
But mull it over. I appreciate your attendance today. Anything else?
Two last very quick questions.
Mr. Scaringi, you've got a lot of these technical questions.
On the motion for permission for leave to amend and file a second complaint, may we waive the local rule requiring concurrence or non-concurrence among defendants, considering there are 7?
Yes, we'll non-concur now, please.
Yeah, they have an oral non-concurrence. Do all the defendants present agree you will not concur in this particular motion? Are all defense counsel?
Yes, Your Honor.
Well, I guess Ms. Hangley, you're here on behalf of your. It will. Yeah.
State certification deadline November 23rd, and the hearing on Thursday being canceled, postponed. Does the court have any idea, indication as to if the motion to dismiss is resolved in our favor when
No, I've got to recalculate that. I haven't continued it. I've canceled it. If it needs to be rescheduled, you'll know. We'll talk on the phone. I'll convene another telephone conference call with counsel, and we'll set a date as next week. Is there anything else today?
Your Honor, I'd like to say one thing on behalf of reality is, and without going in great detail, she's been under a lot of attack as a result of this case. So the call from the gentleman from Kirkland and Ellis, and I have not heard the conversation. She hasn't shared it with anyone but you. I mean, it was in the context of, you know, the woman needs protection. And that's
Well, it wasn't
kind of
it wasn't a threatening call. It was a call. I would suggest, if I used the word would be mockery.
No, but the reason I say it is, I just want you to understand the context in which.
No,
It's not kind of a neutral situation where you get a call like that and you can evaluate it. It's a situation in which she's been put under extraordinary pressure.
Yep.
And part of the reason for the confusion in the different complaints, which I see you noted, is because our original counsel also was kind of forced off the case because his law firm wouldn't allow him to do it.
Well,
I think it's pretty outrageous.
The press suggested that, but in their motion to withdraw, they gave me a more anodyne, you know.
Yeah, well, that's not exactly.
Speculate, but I mean, I think that's regrettable. You should be able to represent your clients, and that's without difficulty. Which criticism is. Now, this is what I suggest you do. This is off the record, by the way, Lori. Thank you. And remember, give your business cards to Lori Shuey. Oh, no, it's off the record, but people can listen in. That's fine. Now, I want to tell you, if you're staying over in Williamsport, and some of you will, some of you will not, eat at one of our restaurants. There's some excellent restaurants here. I don't know whether they're. No, I'm quite serious. Well, you know, if they're open, a lot of them were not open last night. I sent the Marshall's here. Marshall, did you go down to the Old Corner Hotel? How was it? What was it? So there are a couple of places if you're staying over. And I know those of you, I go into these large cities, until recently, fairly regularly. But there is, you don't want to hear the story. There is a culinary school here in Williamsport. So when I was growing up, it was the old Williamsport Area Community College. And back, I think, in the 1990s, it was taken over by Penn State, which is about an hour and 10 minutes. Mr. Please is here. I assume you're in State College. About an hour and 10 minutes away. And they made it their technical school. So it's not the Pennsylvania College of Technology. And they have a culinary school there. It's good. It's not Hyde Park, but it's good. And there's a number of chefs are from the area, and they want to stay in their home community or neighboring communities and ply their trade. So there are better than usual restaurants in this rather small upstate Pennsylvania city, which my colleagues from Scranton and Harrisburg, which are not, you know, culinary capitals, you know, have disdain for. But when I take them out to dinner, when they come there, they're pleasantly surprised. So the Marshal will tell you, he's in the back of the room, the Old Corner Hotel, which I think was open last night, is terrific. They have and I'm sure they can go in. Do you have any problems getting seated, Marshal? Yep. So they have a nice big, it's an old hotel. It's an old Victorian hotel. There's a horse bar, beautiful old, kind of Victorian, sort of a modified Victorian, but kind of arts and crafts style dining room. Their food is very standard food. It's very good food. I don't know if they're open tonight, but on the way down the street toward the county courthouse is Barrel 135. And again, you know, the chairs are wobbly, and it's kind of a martini bar, and there's art on the wall that you would never, ever purchase. But the food is exceptional. There's a young chef in there. He's a lovely guy. Before the pandemic, I ate there at least once a week for lunch. It's a very, very good restaurant. I don't know whether the Peter Hurtig House is open, being Tuesday night. That's in this direction. Again, almost walking distance. It's a beautiful Italianate mansion that was put up in the 1870s by one of the local lumber barons, whose name was, the eponymous name, Peter Hurtig, a very, very wealthy man, owned a lot of property up in my home county, Bradford County as well. That is an excellent restaurant. I don't know if it's open tonight. It's a beautiful, the decor is beautiful, it's first rate. And there's another restaurant called the Salvas. Again, I don't know if the Salvas is open on a Tuesday night. They used to be. That is a leading kind of high-end Italian restaurant. Again, probably a little bit beyond walking distance, just on the other side of like Common College, kind of the end of 4th Street. There are other places. There's a terrific Irish pub. Did you check that out, Marshall? I think they're closed tonight. Called the Moon. I call it the Irish pub. It's the Moon and Raven. And that's that's just around the corner. That's on the corner of 4th and William Street. That's worth going to. And then just up this little alleyway, if the police have kind of blocked off the building for whatever reason, if you go up this little alleyway, which is called Government Place, to the corner across the Community Arts Center is a brew pub called the Bullfrog Brewery. So a lot of frog decor. If you can overlook that, a lot of vivid green paint. But if you overlook that, again, you get a good sandwich in there, and they make their own beer. I'm not a big beer drinker, but it's you know, it is what it is. It's good. So if you are staying tonight, I know the default is go over to Wegmans, and I sound like it typically is a shill for Wegmans. Jury's in here, and you go over to Wegmans and get a sandwich, you go back and sit in your room and you know, do the post-mortem with the argument. What's this judge going to do? But go out to dinner, and I would suggest Giuliani Donovan ought to go out to dinner, and you could get this wrapped up.
Nice ticket, you know?
All right.
Join us?
Not tonight. I have another plan, but another time. All right. Thank you, counsel, very much. Court is
Thank you,
adjourned.
Judge.
All right. Yes. Good night. Lori, thank you very much.
He's a character. He's a real character.